Just reminding you guys, you're still under oath. And we will continue on with questions from commissioners. Commissioner Kimmerite, you may proceed.
Good morning, Mr. Stillman. I have just a couple of questions about the PIMS and specifically about metrics B and C that you testified to yesterday. And I'm looking at page 3, which is the Renewable Integration Encouragement PIM metric B. And I have a clarifying question for that metric. And I want to make sure that I understood your testimony correctly yesterday about the Green Source Advantage Choice program. And I thought that you said that that subscription under, assuming that that program is in fact approved by the commission, that subscription would not apply to this metric. Did I hear you correctly about that?
If I said that, I was incorrect. If Green Source Choice is actually one of the first programs that would apply to this PIM.
Okay. Yeah, and so I had seen under the eligibility, it appeared to me that it would be what it would be applicable. And that's even though the metric is encouraging the new designer programs, but that is still the intent to have Green Source Advantage Choice apply to this metric.
Yes, certainly. Yes.
Okay. And then I had a couple of questions for clarification about metric C, which is the interconnection of utility scale renewable resources. And I didn't see any testimony about the renewable resources that would be applicable. I assume solar, obviously, and solar plus storage. What about standalone storage? Would that apply to this metric as well?
As it's designed, it would not. I don't think there's any of that that's in the plan right now. So we really built this off of the solar and storage that was in the carbon plan.
Okay. And then you had some questions yesterday about the carve out for this metric, where if the third party that's interconnecting does not perform the work necessary for the interconnection, that those megawatts still count toward this metric. I think you recall that testimony yesterday.
I do, yes.
And I just wanted to clarify the record because there was some discussion yesterday about the statute, which 62-133.16 C3, and there was some talk about that this PIM has to consider performance that is within the electric public utilities control. And for clarification, under 62-133.16.3, it talks about being solely or primarily within the electric utilities control. So I want to focus on the primarily language because I don't think we talked about that yesterday. And I think you testified yesterday that this is an incentive only metric. And so is your testimony based upon the primarily language, you still believe that it's appropriate to have this carve out for the metric?
Yes, in fact, I think the carve out is what supports the what's in C3 that you read about the utility having solely or primarily within its control.
Okay, thank you. I just wanted to clarify the record about that primarily language.
Yes, thank you.
Thank you.
All right, any additional questions from commissioners? All right, we'll take questions on commissioners' questions beginning over here.
Good morning. I have a handful of questions for you both. Chair Mitchell asked about risks specific to the Carolinas and asked you to discuss those. And Ms. Bateman, you said the carbon plan was one of those risks.
The execution and just the new technologies that would have to be added and the transition of generation, and that all of that creates more risk for the utility.
Are you aware of other states that have carbon emissions reductions legislation requirements?
So I don't know if they're exactly like ours, but I know there are states that have clean energy type legislation.
So North Carolina is not unique in undergoing this transition.
I wouldn't say, well, it depends on your definition of the word unique. I don't think it's common. It's common across the country at this point. I think there are a handful of other states that have clean energy legislation.
I should have made a map, perhaps. Are you aware of any proposed federal legislation or regulations over the last few years that would have targeted carbon emissions reductions?
I'm not aware.
You were involved in the company's carbon plan proceeding, correct?
Yes.
Do you recall discussions during that proceeding about the state of the coal markets?
I do not.
Do you recall discussions regarding the company's access to natural gas supply?
Yes, I remember some of those.
Is it fair to say that there are risks if the company failed to diversify its generation portfolio?
Yes, I would say that there would be risks either way.
Commissioner Claudefelter asked if you would have used the same customer class cost allocation methodology in absence of the settlement. Do you remember that question?
I'm sorry, can you repeat that?
Yeah, and it's a long one. He asked if the company would have used the same customer class cost allocation methodology in the absence of the settlement.
Yes.
And you pointed to the South Carolina rate case where the company both proposed and the 12CP method was ultimately adopted, correct?
Well, I think I pointed to that later in the questioning. I think my answer to the initial question was that it's hard to say because we had a settlement before we filed.
Fair enough. South Carolina does not have residential decoupling, correct?
That is correct. They have net lost revenues through the energy efficiency rider. So it's a lost revenue adjustment mechanism, but it's not decoupling.
Would you agree that residential decoupling makes residential revenues more certain compared to other customer classes?
So I think it is one mechanism to do that. I think higher customer charges is another way to do that, and net loss revenues for energy efficiency obviously is one step towards that goal as well.
And Commissioners Hughes and Claudefelter both asked you questions about the risks of a PBR application, both to the customers and to the company. Do you recall those questions?
Yes.
The company is not required to file a PBR application, is it?
Correct.
And so given you have filed a PBR application, is it safe to say that the company has determined that the advantages of a PBR application outweigh whatever risks there are?
Absolutely. I mean, I think a PBR application, I think performance-based rate making is a great tool. I think it's great for the company. I think it's great for customers. I don't think it's any less risky than what's in place in other parts of the country on average. But I do think I'm very much supportive of it. As was pointed out earlier, I was on the NERP subcommittee that studied performance-based rate making and contributed to those recommendations. So very much an advocate for it.
Thank you. No further questions.
Good morning, Ms. Bateman. I believe all of my questions are going to be directed to you. Yesterday, Commissioner Claudefelter asked you, as you were just talking about with Mr. Moore, yesterday, Commissioner Claudefelter asked you about risks to ratepayers of PBR and the MYRP, which, as he pointed out, is required by the commission to be considered pursuant to House Bill 951. In recent years, it's true, is it not, that DEP has been coming in for a general rate case approximately once every 3 years?
So I would say we came in 17, in 19. I would say that there was a little bit of a gap before the filing in 2022 because of COVID. But I would say, so I guess in my mind, I'm thinking closer to 2, but it could be 3 if you include the COVID impact.
So over the last 11 years, the company has filed a total of 4 rate cases. Is that correct?
That sounds about right.
And that would be docket number E2 sub 1023 in 2012, followed by sub 1142 in 2017, and then sub 1219 in 2019, and now sub 1300 in 2023?
Yeah.
Okay. And so when you testify that the MYRP provides ratepayers with certainty, you mean the certainty that they will be guaranteed to experience 4 separate cumulative increases in base rates during the course of 3 years?
No. So you referenced those other rate cases, but there was no certainty of when the next rate case would be filed. So you can say on average, it was 3 years, but there was nothing that a customer could plan to, could rely on. And I think your own witnesses, whether in this case or in the carbon plan, testified to the benefit of having some projection of rates. I know this doesn't include fuel, but for at least for base rates, there is some certainty for the next 3 years, whereas under traditional rate making, even if we didn't file a rate case for 3 years, there was no way for the customer to know what our plans would be. So I do think it provides more certainty for the customer than what was in place before.
But you acknowledge that this will mean more frequent rate increases to base rates for customers, correct?
I think it has more frequent but smaller, excuse me. And so I think that's still a benefit for customers to have it kind of small, more frequent rate increases than to kind of wait and have a big jump up and wait and have a big jump up.
So wouldn't it be fair to say that PBR and MYRP put ratepayers at risk of not being able to afford to continue paying their electric bill?
I would not agree with that because like I said, it steps into those rate increases more gradually than the traditional rate making.
You were here for witness Reed's testimony, correct?
Yes.
Okay.
Or watched it online, one of the two.
And you understand that witness Reed acknowledged in her testimony, Direct Exhibit 9, the anticipated impacts of price-induced demand erosion?
Yes.
Thank you. That's all.
Good morning, Nadia Lohr with the public staff. Ms. Bateman, in response to a question from Chair Mitchell, you stated that the 4% cap on increases in each year of the MYRP is a customer-friendly aspect of performance-based rate making. And you also said in response to questions from Chair Mitchell and Commissioner Clodfelter that the approximate $5 billion in projected non-MYRP capital spend would be recovered in the next rate case. And I just want to clarify, the annual 4% cap that applies to the MYRP, that does not apply to the non-MYRP capital spend. Isn't that right?
That is correct.
Okay, thank you.
But I would also just add, I think in my response, I said that non-MYRP capital would be negative regulatory lag for the company and that there's other positive regulatory lag. And so it's not just that you have one dynamic going on, you have both. And hopefully the company will be able to manage those so that we don't under-earn during the MYRP period. But that is the goal, but some uncertainty with that.
So I just have a couple questions on Commissioner questions. In response to Commissioner Clodfelter's questions about risks to ratepayers from the company's PBR application, you mentioned many, customer groups in NERP supported PBR.
Yes.
However, some of those same customer groups who supported PBR as a general concept did not, in fact, support House Bill 951.
Yes, I would agree with that. But I would just clarify, so there's different versions of it, but the NERP version, if you look at, there's a version of the legislation in the NERP report out from the performance-based rate making sub-team that had the NERP version of proposed legislation. And of course, there's the caveat that not every member of the sub-team supported the proposed legislation as written, but that was kind of what was put forth. And then through the legislative process, different stakeholders and interveners put their own, and legislators, of course, drafted their own version of that and made their changes to it. And if you think about what changed between NERP and HB 951, decoupling was limited to just residential. The caps, the 4% increases were added. The earnings sharing band, the concept of it was in NERP, but the 50 basis points was added in the 951 legislation. The restriction about new generation over a certain dollar amount was added in the legislative process. The framework for the multi-year rate plan, instead of being just kind of broad and open as what was in the NERP recommendation, it was very specific that you start with a historic test period and only adjust for excuse me, costs and benefits related to specific MYRP projects. So those are just a few of the changes that were added. And so I understand there were some groups that didn't support the legislation. Maybe it didn't have everything that they wanted. But those are just some of the changes that were made between NERP and what was finally passed.
Take your point, but just on the narrow question, my sole question is, there were customer groups that did not support House Bill 951 in the version that it was enacted in. That's my sole question there.
I'm sure there were some, but I'm not really familiar. I did not take a poll or.
Yeah, moving on. In response to commissioner questions, you discussed other states taking years to establish tracking metrics.
Yes.
One of those states was Hawaii. In fact, Hawaii, the Public Utility Commission there convened an investigation prior to the first PBR application being filed.
So when was that?
So the process basically started around 2018, and there was basically, it was a multi-phase iterative process through which the Hawaii PUC, in collaboration with stakeholders, basically created sort of the overarching regulatory framework before Hawaiian Electric actually filed a PBR application.
So I would agree with that, but I would also point out that they had multi-year rate plans and decoupling in place before that. And so I think that was my point, that they had the multi-year rate plans and decoupling components in place for quite some time before they started adding the PIMs to make it a full PBR package.
With respect to the process that I just discussed, though, PUC in Hawaii took 2.5 years developing and refining that governing PBR regulatory framework.
And that is consistent with my understanding that there was, a time of investigation and identifying tracking metrics and tracking those metrics before any PIMs were put in place.
And going back to sort of an initial set of commissioner questions with respect to North Carolina's state-specific risks, when you're thinking about House Bill 951, one of the ones that you mentioned was coal retirements. You would agree that other states are also seeking to retire coal?
Yes, but I'm not sure. I think, and Ms. Witness Turner could speak, more fully to this, but I think the amount of coal that we're retiring in the time period that we're retiring it is unique, is that we stand out for that.
No further questions.
I just have a quick question. I believe it was Commissioner Duffley's question on your map that you're going to file as a late filed exhibit. Have you broken that down by states that have vertically integrated utilities and deregulated states where it's just transmission and distribution?
I did not identify that difference on the map. It was solely, and I looked at states regardless of whether they were vertically integrated or wires only, whether or not they had future test years, capital trackers, multi-year rate plans, formula rates, and decoupling, and then just marked where they had 2 or more. I gave them the same color.
Do you know that information? Which states are T&D and which ones are, just wires and which ones are vertically integrated states?
Not up here today, but I'm sure we have that information somewhere.
Okay. I guess I would ask if the commissioners would like that information too. I think it might be helpful, but I'm not the one to request it. So thank you. That's all the questions I have.
Thank you. Craig Schauer on behalf of CUCA. A few more questions about this map. So my understanding is the map is based on information that Duke provided in response to SIGFR's data request number 6.
No, so I should clarify. It is based on a cross exhibit from the public staff that I think was used with Dr. Moran, where the public staff had attempted to make some maps. So I used that as a starting point, and then I supplemented it with some information from the NERP process, and then also from Pacific Economics Group. We have had them as a consultant throughout this process.
Right. And the and the map identifies jurisdictions that have the option of certain rate mitigation mechanisms,
Yes.
correct? Okay. The map doesn't identify which proxy companies used by Dr. Moran currently have a multi-year rate plan, does it?
So it does not have that, but I do have a separate chart that does have that information, that has for each proxy company for at least one of their jurisdictions that they operate in, whether they currently have a multi-year rate plan, a formula rate, a forward test year, a wires infrastructure capital cost tracker, a generation capital cost tracker, or a decoupling mechanism. And those were the numbers that I quoted the other day, that for the proxy group, the 23 proxy group companies, 9 of them have a multi-year rate plan in at least one of the jurisdictions that they operate in. 5 have formula rates. 20 have a forward test year. 14 have wires, infrastructure capital cost trackers. 14 have generation capital cost trackers, and 8 have revenue decoupling mechanisms. And I would be happy to file that as a late filed exhibit as well, if the commission would like.
So one question, just to clarify, that those are 9 proxy companies that have an operating subsidiary that currently is operating under a multi-year rate plan?
Either currently, recently had one approved. I think, look at my notes here. Or just ended one. So I think there's 2 companies where it was just recently approved, and one where it, I guess maybe I need to either a recent one or current one.
Or it sounds like one recently stopped.
I'm not sure.
Okay.
So that's Dominion. So I think that's maybe a little unclear right now.
Right. Thank you. No further questions.
Yep.
Thank you, Chair Mitchell. Just a few. Mr. Stillman, I wanted to follow up and ask a couple of questions on metric B of the renewables integration and encouragement PIM, and follow up on Commissioner Kimmerett's line of questioning regarding whether or not this PIM, whether or not it applies to the GSA Choice Program. And she noted how, if approved, that this PIM is designed to encourage the design of large customer programs, and GSA Choice program is already designed. And so my question to you is Metric B designed to incent the development, approval, and customer subscription to renewable programs like the GSA Choice program?
So the answer to that is yes. And I think because there's so many different GSA programs out there right now, I think there's some confusion around what's Advantage, what's Bridge, and what's Choice. And if we go back to my direct testimony where I talk about Metric B, I say that the Metric B is for customer programs that are approved by the commission subsequent to the filing. So that is in line with C and other programs that may be developed over the multi-year rate plan that may be brought before this commission and identified as a program that's eligible for Metric B.
Thank you. And is the incentive reward dependent on customer subscription?
Yes, that's the numerator of the calculation.
And in the company's GSA choice petition, didn't the company indicate that if approved, this program would count towards metric B?
It did.
Thank you. And then Chair Mitchell, I would just, again, as Ms. Bateman volunteered, we're happy to file the backup source material, if you will, for the map that Ms. Bateman prepared, and we are intending to file that as a late filed exhibit as requested yesterday by Commissioner Duffley. And then I wanted to also offer up Mr. Stillman before he is excused. I know that there were a handful of questions relating to weather normalization and load forecasting. And I would just like to point out to the commission that Mr. Stillman would be the appropriate witness to answer those questions, to the extent there are any.
All right, I actually have a few questions. Let me check in. Do you have any questions? Any other commissioners have questions that they would like to put to Mr. Stillman? All right, and Mr. Stillman, just for my own edification, load forecasting. In December, we saw a deviation from, a deviation between what you all actually experienced versus what was forecasted. Do you, what is the company going to do going forward to mitigate for this, for the potential for deviation? And what are you anticipating in terms of either load growth or changes in usage patterns as a result of continued electrification of home heating and just space heating in general, and electrification of all kinds of vehicles?
Yes, so there's a lot there, so if I don't hit on all of them, please remind me what I missed.
I will.
But the first point about the event that we saw in December, what was interesting about that is it was a little bit unusual in how rapidly the temperatures declined. Actually, if I look at the average temperature of that day, it was well in line with what we predict or what we use for our forecasts for winter peak. And if I look at a lot of times what we do for long-term forecasting, I should say that what I'm responsible for is the long-term forecasting that's used in the IRP plans and things like that. But when you look at the peak that occurred on that particular day, it was only ranked number 3 or 4 out of when I look at like the last 4 or 5 years. So it was within the range of what we would expect and what we forecast for in terms of the winter peak. I think there were just other extenuating circumstances that I know you all know about that also occurred on that particular day. So as we go through time, I think it was brought up that we use 30 years to look at weather to come up with what we think what normal weather looks like. And one of the items that we pay particular attention to is that by using that 30-year of data, that we don't lose the weather sensitivity that we experience in winter. So we're very focused on making sure that the winter peak is representative of what we expect going forward. So I'll pause there and see if that helped with it, at least that part of the question.
So that addresses a question about the weather normalization and your use of historical weather data. I'm really more concerned about anticipating load and making sure that the models and that the human beings that work in your company understand and anticipate what's happening with electrification, be it heating or vehicles. I mean,
Yes.
Duke was not the only electric utility that experienced some deviation between actual load and anticipated load. And so I'm concerned again, as we're thinking and talking about risks that this company is going to have to manage going forward and be in a position to address going forward. Assure me that you all are working on looking at what that electrification is going to do to your system and your system's ability to serve load reliably.
We certainly are. And again, I'll go back to the carbon plan in the appendix where it shows the load forecasting. It shows kind of, there are tables in there that show what our load is that comes out of the models. And then we add in electric vehicles and solar and, all of the other items that you talked about that are emerging and would cause changes to the load shapes, including time of use rates. That's one of the columns also. So we're very attentive to that. We're very aware of the electrification that is happening. Electric vehicles is really the largest piece right now. So that's the one that we paid the most attention to. But as the IRA kind of settles out, we'll also look at what the other electrification technologies and incentives are to be sure that we incorporate that growth into our forecast. And having said that, again, we pay particular attention to customer growth also. The Southeast is an area where we've seen very strong customer growth. I think the Carolinas have ranked in the top 10 in terms of where people are moving to in the last number of years. So we're definitely including all of those things, including working with the teams that look at the AMI data so that we can get more current updates on how our load shapes changing, how are people's usage changing, so that we can incorporate that into our forecasts that are provided to other people, other planning areas.
In your sort of, to your knowledge, based on your experience in other jurisdictions in which Duke operates, as well as your engagement across the country in these matters, is the growth experienced here in North Carolina or anticipated here in North Carolina, both the residential load growth as well as the non-residential load growth? Are we, is it unusual, or is it typical? I mean, where does it fall out in terms of what is going on elsewhere in the country?
So as I look at, I'll talk first about our 6 jurisdictions. As I look at the 6 jurisdictions that we're responsible for, from Indiana down to Florida, the Carolinas does have a higher rate of growth than what we're seeing in many of those other areas, especially when you consider not just residential, but the commercial and industrial that's coming to the area. So there is more growth occurring in the Carolinas. As you look at it across the country, I would say that would also play out, especially because as you look at migration patterns and you look at where people are moving from and where they're moving to, again, the Southeast is the area that people are moving to.
Okay. Ms. Bateman, one follow-up question for you. You testified in response to a question from counsel. I can't remember who, but you indicated that this is, in this case, you all engaged on issues of affordability and reaching lower income customers more so than you had done in previous cases. Is that, do I recall your testimony correctly?
Yes.
Okay. Can you speak just sort of generally about your level of customer engagement with different customer groups in this case relative to other cases? Would you say that the company has engaged more so with its different customer groups in this case than it has in previous cases?
I think
Let me be specific
Yeah.
in terms of addressing their wants and needs.
And so I would think the low income panel could respond more fully to that question. But from my perspective, just kind of looking at the process, I think the low income collaborative that we requested and that the commission ordered in the last rate case, and going through that process, I see more in this case trying to address low income needs coming out of that collaborative than I've personally seen in prior rate cases.
Understood. And so understood, sort of on a similar but different point.
Mhm.
I mean, has the company also engaged with or committed to engage with certain customer groups in this case and going forward, more so than it has been able to do in the past?
And that may be the case, but I think that would probably be better responded to by the low income.
Okay, understood. I will ask them that question. Okay, Commissioner Hughes, did you have?
So bear with me as I try to lay out this question, and please, if part of it doesn't make sense, wave your hand. So one of the issues of load forecasting that I've been really interested in is how load forecasting overlays with the EE programs, particularly as we move into a future where we're going to have more and more EE programs and hopefully more and more reductions. There's one program in particular that has kind of stumped me, the way Duke has done its load forecasting versus how it views the program wearing EE DSM glasses. And that's the My Home Energy Report program. This is a highly successful program that has an enormous amount of impact on load. It is by far the biggest impact on load of any of Duke's EE programs. I mean, I think it accounts for over 50% of the impact on all load, this one program. And I think 70, if I'm not mistaken, 70% on all the EE residential load impact is this one program. So it's really, I think, an unusual program. The EM&V has come in consistently showing how successful it is and showing what I would consider to be known and measurable results through a just really robust EM&V. So I mean, I really like the program. What has confused me is when I see how the program is treated from base case load projection versus how it's treated kind of in the EE framework. And I'm just trying to reconcile these two approaches, and I'd love to have both your views, but probably a little bit more Mr. Stillman. From an EE perspective, it's been presented to us numerous times, and it's embedded into the rider, that Duke views this as a program as a one-year program that essentially every year starts from scratch. And that's the way it's been presented to us. And we don't have evidence to know exactly what would happen if the program stopped. But the way it's been presented to us is that if the program stopped, all the savings would go away. And there's lots of testimony to that effect. So with all that said, where I've been scratching my head is from a load forecasting standpoint, I would think your group, Mr. Stillman, would be told that there is an EE program that's going away. It might start again, but it's a brand new program that will start again. So I don't understand when you're doing your forecasting into the future and you're looking at a test year and trying to move that into the future, why you wouldn't adjust for the impacts of taking away that EE program, just as you do for adjusting the impacts for weatherization. So if you know next year is likely to be different than last year, you take an effort to do it. And I was struck by even the magnitude of these different potential adjustments. Weatherization, I think, weather normalization, I think resulted, I think, in a 54,000 kilowatt hour adjustment in this rate case or something close to that. The EE program, the MyHER program, has known and measurable impacts of over 180 million kilowatt hours last year. The test year. Well, I'll stop there because I think you want a clarification, but I want to keep going. But
You keep going.
So where I'm struck is, why wouldn't your team adjust the test year into the base year by adding back that 180 million kilowatt hours saved? Because that's embedded in your actual metered usage, that there's 180 million kilowatt hours of dampened use that only lasted a year and is next year going to start over. So I just don't understand why there isn't that adjustment, because if you did that adjustment and then you started next year, and we do continue with the program, and it's a brand new 1-year program that has, say, another 180 or it's increasing at least every year. Maybe it's 200 million kilowatt hours. Then that all gets taken up in the EE mechanism in a way I think is admirable. It's you did not predict that this program would exist. You predicted your revenue requirements based on this program existing. You had this program, and we have a net loss revenue recovery mechanism for you. So on the EE side, it would seem like if you dealt with it on the load projection side, you would get covered on the EE side. As it is now, it's not being shown in the projections. So you're going into next year still assuming that you're not going to be selling that 180 million kilowatt hours. And yet you're still claiming lost revenue in that, saying that you didn't predict that enormous savings in the next year. And this is just an enormous impact for both the company and for customers. And I've just been scratching my head about, it's known and measurable. You have an EMB report. Duke says it's a 1-year program that's not going to, be in effect and not influencing usage in the future. So where is it? Why isn't this adjustment made?
I can speak to the rate case and rate making components of your question, but Mr. Stillman can speak to how that factors into the long-term load forecast.
Okay. So you're exactly right. The MyHer program is a behavioral program that lasts 1 year. But we work with our energy efficiency teams that roll out these programs to ensure that we understand what their expectations are in year 2, 3, and beyond. And as you said, the expectation in the forecast is that even though that behavioral program is a 1-year program, it continues. So there's subscribership or that program will continue in year 2. So let's pretend that the subscription rate is exactly the same and the benefits that are estimated are exactly the same. The level of gigawatt hours that you talked about or megawatt hours that you talked about that are reducing the forecast in year 0, the actual year, would also be put back in place in year 1, reducing the forecast with the expectation that load will be reduced because that program will continue again for year 1, and then we do the same thing for year 2. So we work with the program groups to understand what level of additional customers may be impacted by the MyHer program, so that we can adjust from what we experienced in the current year, and do we expect more or less sales going forward as that program changes in adoption or changes in the level of efficiency that we expect to incur because of that program. So I'll stop there I know you have a weather normal, but I don't want to talk over that see if that answers your question.
No, it gets to it, but it still leaves me a little bit confused. And that program has been increasing. So we do see some more subscribers, and then each subscriber is saving a little bit more. So let's hope that next year it's 200 million kilowatt hours, and your EE group can project that based on the historic impact. Why wouldn't you? That's really just from a Duke standpoint, you losing 20 million kilowatt hours that are new kind of lost revenues that were not kind of in your test year. So why wouldn't then the net lost revenue calculation for the EE program be based on just 20 million kilowatt hours for the additional savings that were not inside the base year, as opposed to starting from scratch and providing the full 200 million kilowatt hours. And it's really unusual with this program because it's only 1 year. It's hard to map with some of your other programs. So I just with your other programs, I like net loss revenue as a potential removal of a disincentive, and I see the net loss potential from Duke and from a forecasting standpoint with all the other programs. I just don't see it with the MIHR. I don't see how Duke is being surprised and assuming that they're going to be getting revenue doing an EE program and not getting that revenue. Everything I see is that Duke has assumed they're not going to be getting that revenue next year, and they don't get that revenue, yet they put forth a request for lost revenue. So I'm just perplexed.
And so I'll speak to the rate case pieces of it, and then maybe it will help bridge that gap, but maybe not. So in the rate case, I think Witness Reed and Witness Jiggets spoke a little bit to this, that we adjust for weather. We adjust our revenue for weather normalization and customer growth. Both Witness Jiggets has adjustments that adjust the revenue side of that. And then Witness Reed, if you look at her Exhibit 4, there's a top section of the exhibit and a bottom section of the exhibit. And I think the bottom section is labeled like revenue requirement for rate design to apply to unadjusted billing determinants. So that adjustment that's made in that bottom section of her Exhibit 4 is the equivalent of adjusting the billing determinants. So we adjust revenue and an equivalent of adjusting the billing determinants. For the customer growth component, we adjust the test year usage per customer for the residential class to the 12 months ending March 2023. So the capital cutoff date, those actual usage per customer for that 12 months ending March 2023. That usage per customer, and we don't try to go beyond that. We don't project what's going to happen next year, what's going to happen when rates go into effect. But I think one thing that is important to note is that usage per customer for those 12 months that are used in designing rates is exactly what goes into the decoupling mechanism. And so to the extent that customers use more or less than that usage per customer based on those 12 months, that gets trued up in the decoupling mechanism for the residential class. So if residential customers do end up using more per customer than is what is in those 12 months, now with decoupling, that money will flow right back to customers through the decoupling mechanism. And I will say the way that we've designed it with the net lost revenues being subtracted out of the decoupling mechanism, if the net lost revenues in EE for the residential class are overestimated and don't, end up truly materializing, that money, that whatever doesn't show up will be flowed back to customers through the decoupling mechanism. And vice versa. If it's underestimated, it will be trued up in the decoupling mechanism. So I think that's something new that kind of enters into that complicated equation, that to the extent for the residential class, the net lost revenues isn't perfect in the EE rider, it gets trued up in the decoupling mechanism.
I followed about 60% of that. But I think I'm someone that needs to see it on paper, and so I don't want to push you anymore. I can reread some of the testimony on the decoupling.
And all I want to just my main point there is that yes, we are using the 12 months of actual usage per customer, ending with the capital cutoff date, and we're not adjusting that up for things that we expect to happen after that. But anything that does happen after that will get trued up in the decoupling mechanism.
I just still wonder if that, I think I get it. And I just wonder if that will have the impact. And it was interesting to me to hear about the approach where it's essentially looking at the numerator rather than the denominator that witness Jigas presented. But why wouldn't you just then go just straight to revenue from this 180 million kilowatt hours that that you expect, that you didn't sell, but you will sell in the future. So why not just figure it out? What was all that revenue that you didn't collect in your test year? And you could have done the same thing that you did for your weather normalization. You could have figured out what the revenue impact was of that 180 and just follow the same procedure you did for the weather normalization. So that's what
So I think for the test year, we do true it up for, I mean, in this case, the test year is 2021. We've trued it all the way up to the 12 months ending March 2023 with actuals. So that's probably better than trying to normalize the test year. But I think what you're saying is maybe could we then make a pro forma adjustment in addition on the customer growth? And, we could, but if we did with the decoupling mechanism in place, you get to the same place, is what I'm saying. And if we did make that adjustment, what other adjustments to customer usage per customer are known going forward as well?
I think you get
And I'll add one more thing. And this is something more for the EE witnesses. I do know that they do something to kind of reset net lost revenues when a base rate case happens.
And I'll end with there. That gets to the heart of it. Under the MyHer program, just by the unusual nature of the program, there's never a reset, even though again, from my perspective, I don't understand why there's not a reset. But it's because of this nuance of the 1 year life. I'm probably going to lose a lot of people here. I probably already lost most of them. I'm going to stop there. But I think both of your testimony has been particularly helpful. But just understanding what you do and what you haven't done is what I was really looking for. So I appreciate that, and I have a kind of good feeling about that.
Go ahead, Commissioner Clodfeld.
Ms. Bateman, I've been listening to the dialogue, and I want to see if I can frame the question this way and see if it helps me. When the company has revenue recovery under the EE rider on account of net loss revenue attributable to the MyHer program, that revenue comes in. Or are you telling us that for purposes of the decoupling mechanism, that revenue recovery is attributed to the residential rate class for purposes of running the decoupling calculations?
Just the residential net lost revenue in the EE rider is then subtracted from the residential decoupling mechanism. So you're not double counting.
Thank you. I thought that's what you were telling me. I wanted to ask you straight up. Thanks.
Go ahead, Commissioner McKissick.
Guess this is addressed to Mr. Stillman. In terms of your modeling, certainly for weather, I mean, one of the things that we heard was that the extreme weather event that took place this past December had not been taken into account in modeling that has been done in the past, because the extreme cold combined with the wind. And of course, what I hear you saying is that the temperature wise, it was within the range of what would have been reasonably anticipated. But what we heard that would occur is that they go back and refine the modeling to take into account the type of extreme conditions which occurred on this occasion. Well, more importantly, what might be projected in terms of future trends. Now but I didn't hear you really say that was what has taken place. Has that taken place, or is it in the process of occurring? Or help me reconcile what I heard from you versus what I heard from Duke
Yes.
back on January 4th or so, somewhere thereabouts.
Yes, yes. So when you hear the word load forecasting, that could mean many things to many people. What you heard on January 4th in those conversations is the group that does the short-term load forecasting. So they're looking a day ahead, 2 days ahead, 3 days ahead. And they're using historical observations with wind, temperatures, all types of variables that are very current so that they can predict load in the next couple of days to have the generation resources to meet them. The load forecasting that I am involved in is much more longer term. So we stay in contact with that short-term group. We learn from that group. They learn from us. There's conversations that go back and forth. But for purposes of long-term forecasting, what we're very focused on is when we look at the levels of the peak or when we look at levels of energy or whatever the customer growth, any of the things that are included in the forecast, do the trends that we're predicting make sense? And when I look at I'll go back to the peak that occurred in Duke Energy Progress on that particular day. It was again, it was about, I think ranked number 3 or number 4. I don't remember which, but it was not an extreme outlier from peaks that we have seen previously. But that obviously enters our forecasting, and the models that we're running now are including those December trends as we try to build out our peaks for the future.
Okay, so you do, I mean, what it sounds like you're doing, you've gotten information in from the people doing the short-term forecasting that then works into your long-term forecasting, so the two are somehow reconciled.
I hesitate to say reconciled because
Okay.
they use more current information. They're looking at much more current weather trends. So they have, when they're running their models, they have from the news weather and the weather department in the company, they have expectations of what that weather is going to look like on an hourly basis or even a sub-hourly basis going forward. So they're informed by that. They're informed by current customer trends, current customer usage patterns. Their models are more real time, is what I would say. We put out a long-term load forecast twice a year. It's informed by all of those things, but to get those updates in, it takes a little bit longer, which is why we pay particular attention to the trends to make sure that they're meeting what we would expect given what we've seen in history.
Okay, and when it comes to extreme weather, let's say with heat, I mean, these type of climatic conditions that are occurring at an alarming frequency, I mean, what have you done in terms of long-term forecasting to take into account what's been observed, say, in the last 2 or 3 years even?
Yes.
Maybe not within DEP territory, but what I would say, looking nationally, and because it could affect us next.
Yes. So again, we update these models every 6 months and run scenarios as needed to support the different planning organizations. So we capture current weather and current weather trends by doing that. And I'll also say we run scenarios to look at what if we, I think you mentioned climate change, for example, the RCP 4.5 that expects, in terms of Celsius, I think it's like a 2 degree change by the end of the century. We'll run those scenarios to see what's the impact over the course of the year. So obviously, as you're running those, your summer, the sales expectations in the summer are going to increase a little bit. The sales expectations in the winter are going to decrease a little bit because of the warming trends. But as we do that, we've got to pay particular attention to the peak again, because we don't want to lose that peak as we're looking at climate change scenarios.
Okay, and in terms of EV sales, knowing what, has been established as kind of targets or aspirationally, I mean, what rate of growth are you projecting in the DEP area if we look at not just over the terms of this multi-year rate plan, but looking at a further timeline horizon like 2030, 2032, I mean, what is it that you are anticipating or projecting in terms of EV
Yes.
vehicle sales and, and adoption rates being high? I mean, particularly when you take into account, Inflation Reduction Act and everything else that's in there to incentivize adoption. I mean, what is it that you're projecting at this time? Because I'd like to get a sense as to what those numbers look like.
Right. So, I'm going to start with the carbon plan again, because it's a good starting point, because everybody has that document and there's tables in there in the forecasting section that show what electric vehicle adoption was expected a year or two ago. Now, obviously, the levels of adoption are much higher, but it's something that really starts to ramp up in the 2028, 2029, 2030 time period, because all these auto manufacturers have to retool their manufacturing line. I know you are aware of VinFast that's come to the DEP territory, and they've got to build the manufacturing plant. There's got to be the battery availability. So during the first, I would say 5 years, or during the next 5 years, I would say, we are expecting higher levels than what we put in the carbon plan a few years ago. But the real ramp up does not start to take place until the late 2020s. And then it starts to be a much higher pace of adoption of electric vehicles. I don't have the exact number in front of me.
You don't have the exact, that's fair. I mean, the things which I've seen nationally and heard about nationally, say by 2030, 2032, you begin to see some problems in terms of having enough generating capacity to begin to meet the needs. If you're looking nationally as opposed to, discreetly within the DEP or DEC territories,
Yes.
would you concur with that observation that I've?
So what you're seeing nationally is when you look at adoption levels across the country, there are some states that adopt more quickly, some states that don't adopt quite as quickly. I think North Carolina's kind of in the middle of that, maybe a little bit to the slower end, but not much at all. All I can speak to, unfortunately, is where do I see load going? I then turn that over to our generation planners and other people that try to solve for how do I meet the load that I'm telling them. I do know that we've had a lot of conversations that they've said that we're expecting more load growth, I think, in our current plans than what we've had in previous plans when you look out to 2030 and beyond.
Well, I appreciate you sharing your insights. It'd be great if you had more data on that, but I guess the data we received in the carbon plan is perhaps the most recent data that's been available. When do you think more information might be available in terms of projected trends as it relates to EVs in particular?
So there are forecasts that are being put together now to support the carbon plan
Update.
for this year. So that's all being developed as we speak.
Thank you.
So just going to wrap this up. I've been trying to pencil it out, just to figure it out. And I realized probably not the time. Use the word double counting. That wasn't my term, but that probably is a concern. Would I be able to request a late file, or could I request a late filed exhibit where you use the MyHer program and show an example calculation of how that will be dealt with, or is going to be dealt with in the decoupling mechanism to avoid, quote, double counting, to show that it's not in the base rates, it won't be in the decoupled base rates, and it will continue to be in the E?
So we can try. So whatever net lost revenues are in the EE rider would be subtracted out of the decoupling mechanism. So we can take a stab at it. I'm not sure if it will get exactly with. We'll take a stab at it.
See what you can stab.
Okay.
All right. Questions on commissioners' questions, this side of the room, the additional questions. Go ahead, Ms. Lohr.
I just have one question to follow up on Commissioner Hughes's questions about the MyHER program and how those EE savings play into this rate case. And this is probably for either one of you, but has Duke considered placing the MyHER program on a moratorium to evaluate how those EE savings play into a rate case, or to test the validity of EE savings from the program?
So I would say no. We're not the EE. We don't represent the EE group, but I have not heard anything about that, and I'm not sure if it's a very successful program, why we would want to put it on a moratorium.
Okay, that's all I have.
Duke?
No additional questions.
All right.
So just for clarification of the record regarding this map and the late filed exhibit, if you could include the information requested by Mr. Smith and Mr. Shower in that late filed exhibit. Okay, thank
So
you.
that's the proxy group and
Correct. And the vertically integrated versus wires
Yes.
only.
All right, with that, I believe we've come to the end of your testimony. Thank you very much for being here with us and providing your testimony. You all may step down. And Mr. Stillman, excuse, okay, all right, well, we will see you later then. And I will take motions from council, starting on this side.
Chair Mitchell, I would just ask that the exhibits to the PBR policy panel, the very direct, the supplemental, rebuttal, and settlement testimonies be marked and entered into the record.
All right, those exhibits to the direct and the supplemental and the settlement testimonies will be admitted into evidence.
Chairman,
Sorry to interrupt. One more exhibit I'd like to enter, and that was DEP redirect, Bateman, Stillman, direct, and settlement exhibit number 1.
All right, and that motion will be allowed.
Thank you.
Okay.
Chair Mitchell, I would move that AGO cross-examination, Bateman and Stillman direct and settlement exhibits 1 through 4 be entered into the record.
All right, that motion will be allowed.
Chair Mitchell, I would move that SICFR 2 cross-examination, Bateman and Stillman direct and settlement exhibits 1 through 3 be entered into the record.
All right, that motion will be allowed.
Thank you.
Chair Mitchell, the public staff would move public staff cross-examination, Bateman, Stillman, direct, and settlement exhibit 1 into the record.
All right, that motion is allowed.
And then I would also ask, with respect to the map that's being filed as a late filed exhibit, if that could be filed as soon as possible so that parties can review it before Ms. Bateman appears as a rebuttal witness, that would be helpful.
Just for information, we're aiming to file that by the end of the day tomorrow.
Thank you.
At this time, NCJC et al. Would move to enter into the record NCJC et al. Cross-examination, Bateman, Stillman, direct settlement exhibit 1. And on a, I guess, unrelated matter, we have 2 witnesses currently scheduled to appear, witnesses Howitt and Posner. I can take this up at a later time, but just at present, I think no parties are seeking cross. And so just wanted to see if the commission had any questions for either of those witnesses. Again, this is witness Howitt would be testifying on affordability issues. Obviously, the parties have reached a settlement with respect to the primary recommendations in his testimony, and then witness Posner, who had testimony with respect to PIMS and the PBR application. So just wanted to see if the commission had any questions. If the commission did not have any questions, I think we would move to excuse both Howitt and Posner.
All right, let me rule first on your motion to admit the exhibit, and that motion will be allowed. Commissioners, any questions for the NCJC witnesses?
Howard guy, I would.
I'm sorry, sir, I can't hear you. That, this doesn't need to be, just, if the answer is yes, then.
How would
yes.
I would,
Just yes.
how would I would have
All right, we will, any other questions for the other? witnesses? All right, the motion is denied as to witness Howitt. Motion is allowed as to your other witness.
Witness Posner?
Yes.
Okay, thank you.
He may be excused. All right, let's see. Duke, actually, we are now, so that confirm for me that Duke now rests with respect to direct and settlement. Okay.
That's correct. So Chair Mitchell, we have come to the end of the first phase of the hearing with most of the direct witnesses all being presented along with a few that were presented on direct and rebuttal. And so if you would like at this time, we could also move into evidence, the testimony of the witnesses that were excused, along with 2 additional settlements that have been filed with the commission since the start of the hearing on Thursday morning.
All right, let's start with the settlement agreements.
Okay.
And then let's move to the testimony of the witnesses that have been excused.
Okay. So Chair Mitchell, with your permission, we would like to move into the record the agreement and stipulation of partial settlement regarding low income, affordability, performance incentive mechanisms, and affordability issues between Duke Energy Progress, Duke Energy Carolinas, the North Carolina Justice Center, the North Carolina Housing Coalition, Natural Resource Defense Council, the Southern Alliance for Clean Energy, and Bolt Solar, and the public staff. That agreement was filed with the commission on May 4th.
All right, hearing no objection to your motion, it will be allowed.
Thank you, Chair Mitchell. Next, we would like to move into the record the partial rate design agreement and stipulation of settlement between Duke Energy Progress, Commercial Group, the Kroger Company, and Harris Teeter LLC. That agreement was filed on May 10th.
All right, hearing no objection to that motion, it will be allowed.
Thank you. That completes the settlement agreements that have been filed subsequent to May 4th, subsequent to May 4th, correct? Would you like us to proceed with moving in the testimony?
Please do.
At this time, Chair Mitchell, we would like to move in the following pieces of testimony, and I'll cover them all and then ask that you roll on them in total. So we would move that the direct testimony of Aretha Hunsinger, filed on October 6, 2022, consisting of 15 pages, be moved in the record. Next, we would move that the direct testimony of the rebuttal testimony of Donna Counsel, filed on April 14th, 2023, consisting of 15 pages and 3 rebuttal exhibits, be moved into the record. Next, we would ask that the direct testimony of Tim Hill, filed on October 6, 2022, consisting of 29 pages and 8 direct exhibits, be moved into the record. Next, we move on to witness Justin LaRoche. Mr. LaRoche filed direct testimony on October 6th with 1 direct exhibit. He also filed supplemental testimony on February 13th, 2023. That included 4 supplemental exhibits. And finally, he filed rebuttal testimony on April 14th, 2023, and that testimony had no exhibits. Next, witness Kevin Murray. His rebuttal testimony was filed on April 14th, 2023, and contained no exhibits. Next is Mr. John Panizza. Mr. Panizza filed supplemental testimony on February 13th and rebuttal testimony on April 14th. Next DEP witness is Tom Ray. Mr. Ray filed direct testimony on October 6, 2022. That testimony included 1 direct exhibit. Mr. Ray also filed supplemental testimony on February 13th, 2023, along with 2 supplemental exhibits. And finally, Mr. Ray filed rebuttal testimony on April 14th, 2023, and that testimony had no exhibits. Just 2 more to go here. Martin Strasburger filed direct supplemental testimony on February 13th, and that testimony included 1 piece of one direct supplemental exhibit. And finally, Mr. Jacob Stewart submitted direct testimony on October 6, 2022, and that included 2 direct exhibits. Mr. Stewart also filed rebuttal testimony on April 14th, 2023. So with that long list, Chair Mitchell, with your leave, we would move that all of the identified pieces of pre-filed testimony be entered in the record at the appropriate time.
All right, I've heard no objection to your motion. The exhibits to the testimonies you've identified will be marked for identification as they were when they were pre-filed. The testimonies will be copied into the record at the appropriate time, as if they were delivered orally from the stand. And exhibits to all of those testimonies will be admitted into evidence as well.
Thank you very much.
All right, with that, we will proceed with public staff. You may call your witness.
The public staff calls Chris Walters to the stand.
Good morning, Mr. Walters.
Good morning.
All right, if you would, raise your right hand, please, sir. Left hand on the Bible. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. All right, Mr. Freeman, you may take it away.
Thank you. Thank you, Commissioners. This is Will Freeman for the public staff. Mr. Walters, if you would please state your name, business address, who you are employed by, a title there, and for whom you are providing testimony.
Sure. My name is Christopher Walters. I'm employed at the firm Brubaker and Associates at the address of 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri 63017. And my title at the firm is Associate.
On March 27th, 2023, did you cause to be filed in this case pre-filed testimony consisting of 99 pages, a cover sheet and table of contents, Appendix A, and 17 exhibits?
Yes.
On May 9th, 2023, did you cause to be filed in this case corrections to page 63 of your testimony?
I did.
On May 10th, 2023, did you cause to be filed in this case a correction to page 31 of your testimony?
I did.
If you were asked the questions set forth in your pre-filed direct testimony, would your answers, as corrected by those two filings in May, be the same today?
They would.
On May 4th, 2023, did you cause to be filed a summary of your testimony?
Yes.
Do any of the corrections impact your summary?
I don't believe so.
Would your summary be the same as when filed?
Yes.
Chair Mitchell, at this time, I move that the pre-filed direct testimony, corrections, and summary of testimony of Christopher C. Walters be entered into the record as if given orally from the stand, and that his exhibits 1 through 19 be marked for identification as they were when pre-filed.
All right, that motion will be allowed.
Thank you. Mr. Walters is now available for examination.
Chair Mitchell, if I might, I believe there are 2 interveners who have reserved time for cross for Mr. Walters. And I just wanted to remind everybody that in our adversarial system, the purpose of cross-examination is to allow a party to examine an adverse witness as to their biases, bases for the testimony, etc. And that it's not the purpose of cross-examination to simply ask the witness, who is not necessarily adverse, what they talk about in their direct examination. That would be friendly cross, and it is improper. And I don't know what questions are going to be asked by the intervener witnesses, but to the extent that it is friendly cross, I just want to give them warning that I will be objecting to the questions.
All right, Mr. Mehta, I note your concern and your warning. One question, my notes that have been revised, I think as recently as either last night or this morning, indicate that there are 4 parties, including DEP, that have reserved time for this witness. Am I missing something?
I'm checking the updated list now. I was going to say that we no longer have cross, but we're prepared to have commission questions.
Okay.
I'm
So,
David Neal for NCJC et al.
right. So I will strike NCJC from my list. So I've got SIGFR, CUCA, and DEP as having reserved cross-examination time for this witness. And we will begin with Sigfer.
Thank you, Chair Mitchell. Good morning, Mr. Walters. On page 78 of your direct testimony, you state that you conclude that DEP's core credit metrics ratios based on your ROE and capital structure would support its investment grade credit rating, correct?
Yes.
And you go on to state that, importantly, my recommended overall rate of return will accomplish these objectives while mitigating excessive costs to DEP's customers and supporting competitive rates that remain just and reasonable from a rate setting standpoint, correct?
Yes.
So to be clear, your testimony is that your proposed ROE and capital structure will not result in a credit rating downgrade for DEP.
Objection, Chair Mitchell. We're talking this is the epitome of friendly cross.
All right, Ms. Kress.
Chair Mitchell, I've got 3 more questions.
Chair Mitchell,
And excuse me, Mr. Mehta, I
Mr.
was
Mehta,
not finished.
Mr. Mehta, let me focus on Ms. Kress. Ms. Kress, just restate your response to Mr. Mehta's objection.
Chair Mitchell, I've got 3 more questions, very brief cross-examination here. And I would just note that it is in the commission's discretion, of course, whether you all would like to sustain or overrule Mr. Mehta's objection. But I think it's fair and appropriate to allow an intervening party to ask a handful of questions related to the testimony that this witness has filed in this rate case.
All right, I'm going to overrule the objection. The commission's practice has been historically to allow open cross. But I would counsel that our time here is in this hearing room is very precious. It's very expensive. And as you might imagine, there is the press of other business that must be that is constant around here. So please limit your cross to that which is absolutely necessary to elicit evidence you feel helps you make your case. In the interest, again, of economy and making the most of this agency's time and the party's time and resources. So let's proceed.
Thank you, Chair Mitchell. So Mr. Walters, you may answer the question. And if you would like me to restate it, I can.
Please.
So to be clear, your testimony is that your proposed ROE and capital structure will not result in a credit rating downgrade for DEP, correct?
That's correct. I did a credit metrics analysis that, based on my assumptions and my recommendations, and based on the results of those analyses, I concluded that it would support their financial integrity and maintain their current bond ratings.
According to your exhibit CCW2,
You said 2?
that's correct.
I'm there.
The proxy group has an average common equity ratio of 40.8%, including short-term debt, and 43.8% excluding short-term debt. Is that right?
Correct.
So in other words, DEP's proposed equity ratio of 53% exceeds the proxy group's comparable equity ratio by 10 percentage points?
Yes.
Nothing further. Thank you.
All right, Mr. Shower.
Thank you. Craig Shower for CUCA. Mr. Walters, in your testimony, the public staff recommended a 20 basis point reduction because of the risk-reducing nature of performance-based regulation. Am I correct?
Correct.
Did you recall, or did you hear Ms. Bateman testify that 9 of Dr. Morin's proxy companies purportedly have an operating subsidiary that currently has a multi-year rate plan?
Yeah, I was here when she stated that.
Right. In your opinion, is that enough to conclude that Dr. Morin's proxy group reflects the risk-reducing nature of DEP's multi-year rate plan?
Not necessarily, and especially if some of those proxy groups are operating within, the same jurisdictions as each other. But, the risk comparability can also, I try to take a big picture view of risk, right? And one of the ways I do that is taking a look at for instance, the credit ratings of the company relative to the proxy group. And as we were just going over my exhibit CCW2, you'll see differences in credit ratings there. And, specifically, I want to look at the Moody's credit ratings where the average rating for the proxy group is Baa2, whereas DEP's rating is A2, which I would note is a 3-notch difference. So it, whether or not that might be risk comparable based on the modern regulatory mechanisms or not, it's certainly not reflective of, I mean, in total within the bond ratings, if you will. Sorry.
So, but just to be clear, it was your opinion that the fact that nine of the proxy companies have an operating subsidiary that has a multi-year rate plan is not enough to conclude that the entire proxy group reflects the risk-reducing nature of the multi-year rate plan at issue in this case.
Yeah, I would agree with that statement.
Okay. Ms. Bateman also testified that 5 of the proxy companies have operating subsidiaries with formula rates. Are formula rates the same as a multi-year rate plan?
Not necessarily, no. They are both considered, I guess, if you will, modern rate recovery mechanisms. But in my experience, especially recently, multi-year rate plans are considered less risky than our formula rates. And that's becoming apparent right now in the state of Illinois. Specifically, the electric utilities have been operating under formula rates for the better part of a decade. And we are seeing right now, after recent legislation, they are allowed to file multi-year rate plans, and Ameren Illinois Electric and Commonwealth Edison Electric are both in the midst of their multi-year rate plans, and the rating agencies have noted the favorable, if you will, framework of the multi-year rate plan relative to the formula rates.
Lastly, Ms. Bateman identified, I guess, 20 of the proxy companies that have operating subsidiaries with forward test years. Are forward test years the same as a multi-year rate plan?
No, they are not.
And how are they different?
I mean, forward test years generally involve the company's forecast of its full cost of service into a future period, including return of and on and non-fuel O&M and income taxes and other expenses like that. So it's fully forecasted test year. And then the multi-year rate plans just vary by jurisdiction.
Well, how would North Carolina's multi-year rate plan differ from a forward test year?
My understanding of the multi-year rate plan in this case is that it's just for the capital investment of the identified multi-year rate plan projects, and it's capped at 4%, I believe, in years 2 and 3. I mean, there's forecasting components of it, if you will, but I don't know that it's necessarily exactly like a forward test year.
No further questions.
All right, we will take our morning break. We will take about 15 minutes. We'll be back on the record at 10:15. Let's go off the record. All right, I believe, Mr. Meta, we are with you.
Correct. Thank you, Chair Mitchell. Good morning, Mr. Walters.
Good morning.
Mr. Walters, Ms. Kress asked you about your proxy group cap structures. The proxy group cap structure numbers that you gave were based on the publicly traded parent company in the group, correct?
Correct. It's the publicly traded group that we use to assess the cost of equity for DEP in this case.
Okay. Mr. Walters, as Mr. Shower pointed out, your final ROE recommendation in this case includes a 20 basis point downward adjustment, correct?
Specifically, yes. But importantly, it was that it stayed within my recommended range. And I guess if you will, staff has historically recommended a 20 basis point give or take decrement for stuff like this, which was consistent with the midpoint of the lower half of my range. So that's about what it was, yeah.
And so when you say staff had historically recommended this, I think if we refer to page 69 of your testimony.
69?
Yes. And specifically footnote 29.
Yes.
That's what you're referring to? That is,
that's what I
the sentence beginning on page, on line 14 with respect to the quantification, public staff has previously argued, that's what you're referring to?
Yes, that's where I'm at.
Okay. You yourself did not do a calculation that resulted in a 20 basis point drop from your otherwise applicable ROE recommendation, correct?
Correct. What I did was I took a look at, I made sure that it stayed within my recommended range. And the 20 basis points so happened to be about the midpoint of that recommended range. As you heard Dr. Morin testify, quantifying such a number would be relatively difficult to do, but I think he even testified to this commission during his testimony that he estimates, I'll stick with the same terms, risk mitigators, to be worth 20 to 25 basis points.
Yes, and he was talking about an upward adjustment based on the fact that a particular jurisdiction might not have a risk mitigator versus the vast majority of jurisdictions that do have risk mitigators, correct?
Right. And we're going from not having that to having that in this case, but that's not all. I mean, there's plenty of reasons to look at a potential reduction in the ROE in this case, specifically as it relates to both mine and Dr. Morin's testimony. As I went over earlier, the vast differences in credit ratings, 3 notches between Moody's or between DEP and the proxy group's rating from Moody's is substantial. And, in addition to that, the requested equity ratio is also significantly higher than the proxy group we use to estimate the cost of equity for this company. So in addition to the multi-year rate plan, there's other evidence to support a downward adjustment.
Mm-hmm. Now, Mr. Walters, if we follow the links in your footnote 29, we would come to public staff testimony presented in cases currently pending before the commission involving Carolina Water Service and Aqua Water, correct?
That sounds correct.
Okay, and if you would look at in the, should be a book probably towards your right of DEP potential cross-examination exhibits. And if you look at exhibit 33.
Volume 2. Sorry, in volume 2.
I'm not sure what volume, but it would be potential cross exhibit 33.
I think I'm there.
You get a workout with these books, Mr. Walters.
You are not lying.
And Chair Mitchell, this is the testimony jointly filed by public staff witnesses John R., although I call him Bob Hinton, Charles Junis, and Ms. Zhang and Ms. Boswell, I believe. No, not Ms. Boswell, but Ms. Sun. Both, at least Ms. Zhang will be appearing later. But this joint testimony of the public staff witnesses in the Carolina Water Service case, docket number W354 sub 400, filed October 26, 2022. And I would like to have the exhibit marked as DEP Cross-Examination Walters Direct Exhibit number 1.
All right. Let me do this. Just bear with me. Let's just so that we're clear, let's mark the document as DEP Cross-Examination Walters Exhibit number 1, as he only filed one testimony.
Okay. And Mr. Walters, if you would go to Exhibit 35, which might be in a different book.
You said 35?
35.
I'm there.
And this is the joint testimony of, again, a number of public staff witnesses in the Aqua case, docket number W218 sub 573, correct?
Correct.
And Chair Mitchell, I'd like to go ahead and get this one marked as DEP Cross-Examination Walters Direct Exhibit number 2.
All right, we will mark it, the document as DEP Cross-Examination Walters Exhibit number 2.
Thank you, Chair Mitchell. And so these are the testimonies of the public staff that are in the links or from the links in your footnote 29, correct?
I believe so, yes. I haven't clicked on the links in quite some time, but I'll take your word for it. That's where they go.
Well, I think that's where I got the documents, so that's good. I'm sure, subject to check, we can figure it out. Is that right? Now, Mr. Walters, you mentioned that there are a number of other reasons to effect a downward adjustment in DEP's otherwise applicable rate of return on equity. For example, the high credit ratings, the cap structure differential between the parent companies, but you did not actually make a downward adjustment with respect to your recommended ROE for those factors, did you?
If I made additional downward adjustments, I probably would have fell out of my recommended range. But taking a look at the total risk comparability in total, I found that to be a reasonable adjustment where I landed.
But the basis upon which you made that adjustment was purely the issue of alternative rate regulation availability now in North Carolina, as opposed to high credit ratings or cap structure, correct?
Can you give me just a second to look through my testimony, please? I would like to refer you to page 28 of my direct testimony, please.
There?
Starting at lines 12 through 16. There I state clearly DEP's requested equity ratio exceeds the equity ratios of the proxy group used to assess the company's cost of equity. As such, an ROE in the lower half of my range would be warranted should the company be authorized its requested equity ratio.
I understand that, Mr. Walters, but you did not actually make a downward adjustment in the midpoint recommendation with respect to DEP's ROE, except for the 20 basis point downward adjustment that is referred to on page 69 of your testimony, supported by the public staff testimony referenced in footnote 29.
Again, I would state that I took into consideration the total risk comparability of DEP, considering all things, while I explicitly referred to both the common equity ratio differences and the multi-year rate plan as it exists now or going forward in this case to make the adjustment.
So did you make a 20 basis point reduction in your otherwise applicable ROE based on the common equity ratio?
Not specifically.
The only specific adjustment you made was based on the MYRP issue, correct?
The only stated explicit adjustment for the ROE is based on the MYRP.
Okay.
But I still contend that there is other reasons to consider it, i.e. the differences in credit ratings and the common equity ratio.
Turn, if you would, Mr. Walters, to DEP potential cross-examination exhibit 53.
53?
53. And I'm not sure which book well, I think that's
It's in the
probably the
last
book
one.
you got.
Let's play musical chairs with the binders real quick. All right, 50. I'm there.
And exhibit 53, or potential exhibit 53, Mr. Walters, is a copy of your testimony before the Florida Public Service Commission in a rate case for Florida City Gas, docket number 2022-0069-GU. Is that correct?
It is.
Chair Mitchell, I'd like to go ahead and mark this one as DEP cross-examination Walters Direct Exhibit 3.
All right, the document will be marked as DEP cross-examination Walters Exhibit 3, Exhibit number 3.
Thank you, Chair Mitchell. I do get them backwards, but you're good at correcting it. And this testimony was filed, Mr. Walters, on, looks like August 26th, 2022?
Yes.
And the party to the proceedings that you filed it on behalf were the federal executive agencies and the Department of Defense, correct?
I don't know that the Department of Defense was a specified client.
Well,
but
federal
that's federal
executive
exec- yeah,
agencies, and
yes.
it's signed by a major in the Air Force, so I just assumed Department of Defense, but I may be.
There's some intricacies there, but close enough.
Is it fair to say, Mr. Walters, that your testimony on rate of return is more typically presented on behalf of large customers like like FEA or large industrial groups than on behalf of a governmental agency acting on behalf of the using and consuming public?
No.
You represent governmental agencies acting on behalf of the using and consuming public as well?
As well as citizens utility boards and public staffs, industrial customers. I've filed on behalf of a utility at FERC. I've filed testimony as it relates to rate of return across a very wide spectrum of clients.
And this particular one is on behalf of FEA, which I assume was a large customer
Yes.
in the Florida City Gas case, right?
Correct.
Now, Florida City Gas parent company is Florida Power and Light, correct?
Correct.
And on page 20 of your testimony, you went through an analysis of the credit ratings information concerning Florida City Gas's parent, Florida Power and Light, correct?
Yes.
And you quote from S&P's evaluation of Florida Power and Light's business risk, do you not?
Yes.
And the last paragraph on the page, carrying over to page 21, reads the FPSC, which I assume is the Florida Public Service Commission, regulates FPL. We, meaning S&P, view the regulatory environment in Florida as constructive and supportive of credit quality. FPL benefits from forecast test years, above average authorized returns on equity, multi-year rate settlements, and various regulatory mechanisms that enable the company to reduce its regulatory lag and reduce cash flow volatility. Further supporting our assessment of the company's business risk profile, it goes on to talk about various storm cost recovery mechanisms, correct?
Correct.
Now, Mr. Walters, your recommendation with respect to Florida City Gas, the subsidiary of FPNL, was in the exact midpoint of your range, was it not?
You point me to a page number?
51?
Thank you. Correct.
Mr. Walters, let's go on to the next potential exhibit, which is number 54.
I'm there.
And this is testimony you filed on behalf of federal executive agencies before the Public Service Commission of Utah in a Dominion Energy matter, correct?
Correct.
Dominion Energy of Utah matter. Docket number 22-057-03, correct?
Correct.
Chair Mitchell, I'd like to go ahead and mark this one as DEP cross-examination Walters direct exhibit 4.
All right, the document will be marked as DEP cross-examination Walters exhibit number 4.
And Mr. Walters, on page 24 of your testimony,
I'm there.
you again went through an evaluation of Dominion Energy of Utah's credit analysis based on S&P, correct?
Correct.
And you recap there S&P's assessment of business risk, correct?
Yes.
And the assessment by S&P, and I'm reading from the second paragraph, begins QGC. And that's what Dominion, Utah used to be named Questar, right?
I'm sorry, you're on line 18, is that right? I just want to make sure I'm on the same line. You said second paragraph?
Second paragraph.
Oh, no.
Well, actually,
8.
line 8.
I'm sorry. Yes. And yeah, if you'll look at footnote 24, or I'm sorry, 10, yeah, it's Questar.
Questar. So, but it's the same company.
It is, yes, you're right.
So QGC effectively manages regulatory risk through a credit supportive rate design, the use of multiple cost recovery mechanisms, including a fuel cost adjustment, a weather normalization adjustment, decoupling, and an infrastructure cost tracking adjustment, correct?
Yes, for the gas utility.
And Mr. Walters, if you would look at what was it's in the public staff book, so probably the one that's kind of up towards the top of the table, the white book.
Okay.
At public staff potential cross-examination exhibit 10.
Sorry, the numbers are upside down.
They're a little hard to find.
All right.
But that's the public staff's book, not my book.
All right, I think I'm here. Are we at the adjustment clauses? That's the rate
Yes,
review?
it's the RRA book.
Sure.
Or RRA exhibit. And Chair Mitchell, this has been, I think, already introduced into evidence, and I believe it is Public Staff Cross-Examination Morin Direct and Rebuttal Exhibit 16.
And that is what my notes indicate as well.
And Mr. Walters, if you look on page 14 of that exhibit,
I'm there.
well, my computer is not loading, so I'm not there, but I'm going to get it on paper. There on page 14, Mr. Walters, we see a entry under Utah for Questar Gas, correct?
Yes.
And the public staff exhibit shows that Questar Gas has a number of different adjustment clauses. There's a check mark for electric fuel, gas, commodity purchase power, a check mark for conservation program expense, a check mark for full decoupling, a check mark for new capital delivery and infrastructure, correct?
Yes.
So, Mr. Walters, not to keep you guessing, I'll just point you to page 60 of your Dominion, Utah testimony.
Which exhibit was that again?
54.
Page 60?
60.
I'm there.
And your recommended ROE for Dominion, Utah was 9.4, which is the midpoint of your recommended range. Correct?
Yes.
And then immediately following that, line 9, you indicate, given the significant differences in equity ratios, an ROE in the lower half of my range would be warranted, correct?
Correct.
Okay. But you did not make a specific basis point reduction due to the differences in equity ratios.
Not an explicit adjustment. I just recommended that an ROE be in the lower half of my recommended range, which would have been from 9 to 9.4.
Okay. So, I mean, that could be 9.39 or.
Correct.
Just like the lower half of your range here could be 1 basis point off 9.44.
You're right.
Nothing further, Chair Mitchell.
All right. Let's go to redirect.
Thank you. Mr. Walters, you discussed some items that informed your judgment about why the decrement was appropriate in this case. Have you reviewed the independent analyst RRA to see what they said about this jurisdiction when HB 951 was passed?
Yes, I have.
What did they say?
I don't recall exactly what they said per se, but I think it was the day the new legislation was signed into law, RRA raised the regulatory environment rating of North Carolina from above average 1 to average, or I'm sorry, they increased it from average 1 to above average 3. So that's essentially a 1 rating increase, and notably that's from the perspective, exclusively from the perspective of an investor.
When you increase the rating, what is that? What does that mean?
It's more, so it's, as I said, it's from the perspective of an investor that RRA takes in these ratings. And so when they increase the regulatory environment from average 1 to above average 3, it leads you to believe that it's more favorable to investors.
Is decoupling the most weather sensitive class of favorable action for a utility?
Yeah, I mean, you're moving to more certain cost recovery. It reduces cash flow risk and rate recovery risk.
What's your analysis of how often do you see those electric decouplings for the most weather sensitive class?
In my experience, revenue decoupling is not as common in electric utilities as it is in natural gas utility rate cases. But I mean, I'm sure there's a handful, but they're not as prevalent.
What about multi-years? How would you say that the landscape is for those for electric utilities?
Sure. They're certainly not widespread. That's obvious whenever you look at the 9 companies out of the proxy group that I believe Ms. Bateman identified as 9 of the subsidiaries, or I believe, or 9 of the 23 companies had some form of multi-year rate plan or formula rate plan. I mean, there are some multi-year rate plans for electrics, but they're not as widespread.
I think Questar is gas, not electric, right?
Correct.
Okay. How would you say that having a? I'm so sorry.
No, you're fine. I wanted to be clear or clarify, if you will. We were going back and forth being Questar, Dominion Energy. It's Dominion Energy Utah, also Questar Gas. So just so everyone's clear on who we were talking about.
We've talked about another thing that I think would affect your judgment of the ROE is the band about which the company can under and over earn.
Yeah. So you're talking about the earnings sharing mechanism.
What do you call that band?
Most often it's referred to as a dead band.
Okay. What's the downward dead band in North Carolina?
From the ROE, there is no lower dead band. So if they were to not earn their authorized ROE, they could come in for a rate case to seek rates based on my understanding. Whereas in other jurisdictions, that 50 basis point dead band to below the ROE, those utilities that have those in place, the plus or minus 50 basis point dead bands, if their earnings fall within the lower half of that, or the lower 50 basis point dead band, shareholders eat those costs generally. Now, if they fall below that, there's some kind of mechanism to bring rates back to produce cost of service.
If you can bear with me for 1 minute, I may be done.
Sure.
Thank you. I don't have any more questions.
Thank you.
All right, questions from commissioners? Commissioner Brown-Bland. Commissioner Plattfelter. Definitely. McKissick. Okay. All right, Mr. Walters. Your ROE analysis used betas for the CAPM of a range of 0.76 to 0.89. Do we understand that correctly?
Let me pull that exhibit up, please.
Okay.
Yes.
Okay. When you corrected Witness Morin's CAPM calculations, you used a beta of 0.7. Is that, do we understand that correctly?
Yes.
Okay. Can you help us understand why you used a different beta in this context, specifically when you corrected Witness Morin's calculations?
Sure. Do we have a copy of his testimony up here? Any of the exhibits? It looks like I cited a page of his testimony. I want to make sure that that's.
Okay, let me see if his counsel can get Witness Morin's testimony in front of you so you can refresh your recollection.
I don't have a paper copy in this room.
I do not have witness Warren's testimony here. It's back in the hotel.
You guys don't have it anywhere over there?
Or it could be supplemental too.
Yeah, I'm got it.
He did file supplement.
I mean, I can put my iPad in front of the guy if we need to do it in front,
Yeah.
so we don't have him up here longer than necessary. All right, thank you, Mr. Josie.
Thank you. It's direct.
Yes, it's direct, I'm sorry.
We have.
Okay. So just, Mr. Walters, let me know when you're ready. Yes. About the notches, yeah.
Sorry.
I'll get it. Gotta just. I got it.
So if I'm there.
Okay. Let me ask you my question again, just so we're all on the same page. When you corrected witness Morin's CAPM calculations, you used a 0.7 beta. Can you help us understand why you used a different beta in this context? And when we say different beta, different from the betas you used in your CAPM.
Thanks for the question. I'm looking at page 44 of his direct testimony,
Okay.
specifically line 6. And he identifies a historical level of beta himself as 0.6 to 0.7. So I just used his own beta analysis to correct for that. Certainly, the betas I used, I used a historical beta, I believe, of 0.76. That could also be substituted in. But the 0.76, I think, is probably a shorter time frame that I looked at, but it's a historical beta that he's identified.
Okay, thank you for that clarification. In correcting witness Morin's historical risk premium approach, you adjusted the risk premium to 6%. Do you recall that adjustment?
Yes, sorry.
Keep his testimony just in case you need it.
You have a page number?
I do not.
Okay, I see it there. It's on page 92 of my testimony, if you would.
Okay, thank you. Oh, so the question again is you adjusted the risk premium to 6% and explain this adjustment to us.
I believe. If you'll refer to page 52 of my direct testimony, lines 12 to 13. As such, I believe an equity risk premium over treasury yields of 6.04% is appropriate given the current economic environment. So I just kind of relied on my own equity risk premium.
Okay. All right. Let's see. You testified some today, and it's in your pre-file testimony about the 3-notch difference from the proxy group to DEP. Is the average Baa2 rating you mentioned representative of operating companies or holding companies?
The holding companies.
Okay. And so can you discuss the appropriateness of the comparison then, given that we're dealing with an operating company in this case?
Sure. I mean, what we're doing here and using the holding companies is the only way we really have an opportunity to assess the cost of equity because they're the ones that are publicly traded. So you try and find companies. It's known as a pure play method to find companies of comparable risk in the same industry to estimate that the subject utility, in this case DEP's cost of equity. So comparing the credit ratings is one of the hallmark methods of assessing the risk comparability between the proxy group and the company itself.
Okay. Your testimony, you were asked questions today about Florida City Gas and Florida Power and Light. You recall that discussion you had?
Yes.
Okay. Does Florida, the jurisdiction of Florida, have a multi-year rate plan, rate making tool in place in that state?
I think there might be some concepts. Forgive me, it's been a while since I've reviewed that testimony or even that case. I know they do have multi-year. I believe in the S&P report I quoted that they said that there are generally multi-year rate settlements, so the company will stay out for X amount of years for particular cost recovery over those future year or forecasted years.
Okay, so were there no statutory authority in place for a multi-year rate plan but settlements were achieved that settlements were entered into that involved a multi-year rate setting, you would regard those in the same way from a risk standpoint?
Well, I mean, the settlements, you don't really know they're going to happen as you're making your ROE recommendation. I will note that I made a significant capital structure adjustment in that case, if I do recall. But sorry, to get back to your point, you know, multi-year rate recovery certainly does reduce risk, if you will.
Okay.
Whether it's through settlement or statutory.
Okay. Additional questions from commissioners? All right, let's take questions on commissioners' questions. We will start with Duke.
No questions, Chairman.
Okay. Anyone on the side of the room? Mr. Freeman?
Just one question. You were asked about betas. What's your sense of the volatility of the electric utilities now and going forward over the next few years?
As it relates to beta?
Yes.
Yeah, so I think this kind of maybe goes back to what Dr. Moore was testifying, that he believes high betas around 0.9 for the utility industry are here to stay for a while. And I don't know that he and I have the same view of that, because especially as it relates to beta, when you're looking at the betas as measured by value line, yeah, they're 0.85 to 0.9 generally. But it should be known that betas calculated by value line are calculated over a 5-year historical period. And as you all are aware, what happened within that 5-year historical period is when the market fell out, volatility spiked through the roof to historical levels, a historic level. And that's what beta measures, is volatility. You know, the impact of COVID at the height of the pandemic, at the beginning of the pandemic in March of 2020 and going forward, are going to be in beta calculations calculated by value line 4 or 5 years after that happened. When you look at more recent or other versions of beta as measured by Bloomberg, which Bloomberg uses 2 years of historical data, you're seeing those go back to more normalized levels of around 0.75. So that's right in line with my average historical value line beta. And I would note that beta from value line and Bloomberg were about the same after COVID was initially accounted for the first 2 years. But after the first 2 years of COVID, you know, after the spike of COVID fell off after a 2-year period, you start to see the more normalization, if you will, of Bloomberg beta going back down to where it had been prior to.
Thank you.
Yep.
Mr. Walters, I'm going to ask you one more question about betas. Your counsel helped me remember a question I have for you. You discussed Bloomberg. We've discussed value line as examples of organizations that calculate beta. What other organizations, companies provide a beta calculation for the electric utility industry?
Sure. There's a handful, as they were discussed, I think, with Dr. Moore on the stand. Zacks.com publishes them, Yahoo Finance. You can get them off CNBC. There's also S&P Capital IQ. I think now Kroll, what used to be Duff & Phelps, they have started publishing their estimates of company betas. There are a lot of industry or firms out there that publish betas for publicly traded companies.
What are your views on the relative sort of values of those other organizations' calculations of beta?
Sure. I have not really looked into how like Yahoo Finance calculates it, or Zacks even. I believe Yahoo doesn't do an adjusted beta, so it's just a raw, ordinary least squares regression beta. And when I say adjustment, there's typically the Bloom adjustment, which increases it for the tendency to move towards 1 over time. I rely on specific. We don't have access to Bloomberg in our firm, so I use Value Line and I use S&P Capital IQ Pro. And I've used those. I've used Value Line for the entirety of my career, and I became aware of the S&P Capital IQ betas probably with the last 2 years, 3 years maybe.
So does your, do you not place much weight on the Zacks calculation or some of those others that you have mentioned, Yahoo Finance that you've mentioned, but that you didn't utilize for purposes of your analysis?
I've just never utilized their beta estimates for my analysis. And I
And
believe,
why is that?
but from my understanding of how Yahoo Finance calculates their raw beta is that they use daily data, and there's a lot of white noise in daily volatility. So the more accepted method is to use weekly and even monthly data over a historical period.
Okay. Okay. All right. Thank you very much.
Thank you.
Let me see if there are questions on that round of questions from me.
Not from Duke.
Mr. Freeman, nothing.
No, thank you.
Okay. All right. All right, Mr. Walters, thank you for being here with us.
Do you want me to take care of all these binders and close them all? Or?
Somebody will help. Hopefully somebody will help you out with that. I will, you may step down and you may be excused as well. Thank you very much for your participation in this case.
Thank you for the time. Thanks for having me.
All right, Mr. Freeman.
Thank you, Chair. the public staff would move that the 17 exhibits attached to the pre-filed supplemental testament, the pre-filed direct testimony of Mr. Walters be entered into the record and marked in the same manner as they were when pre-filed.
That motion is allowed.
Thank you, Chair.
Chair Mitchell, I would move the introduction into evidence of DEP cross-examination Walters direct exhibits 1, 2, 3, and 4.
All right, that motion is allowed. All right, we will now move on to, I believe CUCA, you'll call your witness.
Yes, Chair Mitchell.
Okay.
At this time, CUCA calls Mr. Charles Heilig to the stand.
All right, good afternoon, Mr. Heilig.
Good afternoon, thanks for having me.
Will you raise your right hand, please, sir? Place the left hand on the Bible. Do you swear the testimony about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Shower, take it away.
Right. Good morning. Please state your name and business address for the record.
Charles S. Heilig III at 531 Cotton Blossom Circle, Gastonia, North Carolina.
Right. Mr. Heilig, where are you employed and why did you file testimony in this proceeding?
I'm employed with Parkdale Mills and filing testimony on behalf of the North Carolina associates that have been employed with us for the last number of decades.
What is your position with Parkdale Mills?
I'm the president of Parkdale Mills.
And you filed testimony on behalf of CUCA, correct?
Correct. Right.
So you're the same Charles Heilig who pre-filed testimony on March 27th, 2023, consisting of 10 pages?
I am.
Right. And was that testimony prepared by you and at your direction?
It was.
Right. Do you have any corrections to your pre-filed testimony?
I do not.
If today I asked you the same questions that are set forth in your pre-filed testimony, would your answers be the same as those in the filed testimony?
Yes, sir, they would.
Did you cause to be filed in this proceeding a summary of your testimony?
We did, yes.
Is that summary true and accurate to the best of your information and belief?
It is.
Chair Mitchell, I'd ask that Mr. Heilig's direct testimony be copied into the record as if given orally from the stand, and also ask that his summary be entered into the record as well.
That motion will be allowed.
The witness is available for questions.
All right, CCBA?
Yes, ma'am. Thank you. John Burns for CCBA. Mr. Heilig,
Thank you for being here today. You've testified to the impact of rate increases on the operations and profitability of Parkdale Mills. Is that right?
Correct.
And you noted on page 5 of your testimony that you have your testimony in front of you?
I do.
On page 5 of your testimony, you talk about the impact of rate increases being magnified for industrial customers due to the scale of operations. And you state this dynamic is particularly acute for industrial and manufacturing customers that are typically faced with thin margins reflective of a globally competitive marketplace, correct?
Correct.
It seems to me that it would therefore be helpful to Parkdale Mills to be able to access reliable and affordable energy without the rate increases that are set forth in Duke's proposal here, wouldn't it?
That would be ideal.
Okay. One method of doing that would be to be able to access or provide behind the meter generation of renewable power and electricity for your operations, wouldn't it?
Yes.
Has Parkdale Mills looked into the possibility of such a program or accessing such generation?
We have.
And what have you found, if anything?
We've yet to find available energy sources that would help us reduce our costs during peak demand periods. Looking for opportunities to have alternative generation is something that we constantly review, and we have not found an avenue at this point.
Have you looked at the GSA program that's currently offered by Duke?
We have.
And is that one that fits the profile of your business?
Not at this moment. No.
What about I think you testified a little bit to this, but the economic development rider forecast in the rate filing would not be helpful to your operations, would it?
No, the economic development is not favorable to Parkdale Mills.
Okay. Based upon your testimony, Mr. Heiligen, I don't want to take up too much of your time. It appears to me that based on the situation you've described, if the customer and behind the meter programs forecast by Duke are not developed in a way that is achievable and attractive to your company, Parkdale Mills may be in a position that it would need to close certain operations in North Carolina. Is that correct?
That's correct, yes.
Would you agree that DEP should then be incentivized to work with companies such as Parkdale Mills to make behind the meter and customer and industrial programs more usable and achievable so that they would be adopted by companies such as yours?
That would be ideal. Giving us an opportunity to lower our rate through private and public investment would be something that we would be very, very interested in. Yes.
Okay, thank you. No further questions at this time.
All right, my notes indicate no additional cross-examination for the witness. Is that correct? Okay. Mr. Shower, you redirect, please.
I do have one question.
Okay.
Redirect.
Go ahead.
So, Mr. Heilig, I believe you said that Parkdale Mills is not able to reduce costs during peak demand by use of behind the meter solutions.
At this moment.
Right. Was that specific to North Carolina?
It is.
Right. Do you have certain behind the meter solutions associated with other plants outside of the jurisdiction?
We do. We do. There are different opportunities that present themselves from time to time. We have 3 operations, and we're currently using solar to help us shave load. That opportunity is, those windows open up from time to time. We've been able to take advantage of it in other states and other countries, and we've been unable to do so in North Carolina.
Right. Thanks. No further questions.
All right. Let me see if there are questions for you from commissioners. All right, Mr. Heilig, I have a few questions for you. Just following on the question you just took from your counsel. Where in the United States have you been able to use behind the meter solar?
So we've been able to find opportunity through third parties in Georgia through different windows.
Okay, so in Georgia, you're using,
So
just a follow-up for you there, is Georgia Power the electric service provider?
Yes.
Okay. Have you reviewed or has your counsel informed you about any of the proposed rate designs or rate offerings that are at issue here in this proceeding that might be, for which your operations in North Carolina might be eligible?
So the things that we've seen so far, yes, I have been informed, but we have been unable to find opportunity that exists. And that's through our engineering staff that has presented that to us.
Okay. Could you help me understand the way in which your company uses electricity with respect to your operations here in North Carolina and DEP?
So we're an industrial consumer. We have a very high load factor. So our facilities run 24 hours a day, 7 days a week. We add to the improved efficiency of Duke's footprint. We build a large facility, we install equipment, and that equipment, it runs pretty much all the time. So when we talk about high load factors, I mean, when we're on. The only time we shut our facilities down historically has been July 4th and Christmas.
Okay.
In really good years, we only shut down Christmas Eve and Christmas Day. So in the way that we consume energy, some of the substations we own, some of them Duke Energy owns. It just depends on the buildings that we buy or the communities in which we operate, and some of the economic incentives from the counties as we begin the construction process.
Okay. In your testimony, you indicate the amount of money that your firm spends in energy costs in North Carolina each year, and that number is confidential. So I don't want to.
Yeah.
I won't ask you to go into the
Right.
specifics of that number. And you testify that all of that or almost all of that comes from electricity use. Do you recall the testimony I'm
Yes.
referring to?
Yes, I do.
Okay. And how much of that total amount can be attributed to your facilities in DEP?
I think our total bill was a DEP bill, if I'm not mistaken. I need to look. I don't think we put our total spend company-wide in there.
Okay, so the number that's cited in your testimony is
says
specific
in-
to your DEP facilities.
It says in North Carolina, yes, yes. So we only had one facility that was in Dominion at some point. The rest of them are all in DEP.
Okay, I'm sorry, I did not know that. So
Yeah,
you have no facilities in DEC.
In DEC, I'm sorry, DEP to DEC. So of that number, 30% is DEP compared to DEC.
Okay,
And that's roughly, I'd have to get the actual number for you, but
okay.
I don't mind telling you, the bill under DEP is somewhere around $6.5 million a year.
Okay. And what can you tell me? I recognize that you're not an engineer. I don't believe you're an engineer, but what can you tell me? And if I'm wrong about that, correct me. But what can you tell me about the discussions you've had internally with engineers at your firm regarding your operations ability to take advantage of rate offerings from DEP that might be tailored towards the way in which you operate your facility?
So from my understanding, we are on the most efficient rate from DEP at the moment. So 1% of our load is on real-time pricing, the other is on fixed pricing. So that is the only option and best option that's available to us at the moment.
And does that include the options that have been proposed by DEP in this case?
We believe that we're on the most efficient option at the moment, even the proposed option.
Even if the commission were to approve the options that DEP has put forth here, you all would remain on your current.
We do not see a rate that offers improvement to Parkville.
Okay. Do you all, I assume that your accounts are managed accounts
They are,
with DEP. So DEP has assigned a manager to your account.
yes.
Can you talk to me some about the relationship between the account manager and your firm? I'm just interested in the level of engagement.
Reasonably engaged.
What does that mean?
We do have account managers and they engage with us on a reasonable level. I mean, I don't know what
Does the account manager from DEP work with your your internal engineers to identify opportunities or
Yes.
different
yes,
rate programs or
Absolutely.
other types of programs in which you all may participate?
Yes.
Does your company participate in any DSM or EE programs?
No,
Has your company opted out from participating in such programs?
we do opt out. Yes.
And what measures have you instituted internally that provide for energy efficient that achieve energy efficiency or otherwise manage your demand?
Well, okay, so most of our equipment that we purchase has a fixed usage rate, and we're buying the most efficient equipment that we can at all times. The opportunity for us to upgrade is actually detrimental to the state of North Carolina. And our upgrade, so we buy equipment and the useful life is around 25 years. We have 34 operating facilities in the United States, which means we have to constantly evolve. 2008 was the last time that we invested in DEC or DEP. In 2010, we invested in Duke, South Carolina. 2016, we invested in Georgia Power. 2016, we invested in TVA. 2018, we invested in AEP. The problem is there's no incentive for us to reinvest in the state of North Carolina. We're a North Carolina company. We have a 107-year heritage here. We are incentivized to leave. There is no program that says, we appreciate you reinvesting in new modern technology. The only time that if we have an opportunity to reinvest in new technology, there is no rate that says, thank you for going from 12 megawatts to 10 megawatts. When we do that, there's disincentive for us because we are not creating new load or new jobs. Fortunately for our planet, new technology gives us the opportunity to reduce labor inputs and reduce energy inputs and make our product more efficiently with less harm to the environment. But if we come back today and say, we're going to modernize, the only option we have is to leave. So our last $500 million in investment has been outside of the state of North Carolina. And I assure you that breaks our heart. And even worse than that, all of that investment's within 10 miles of North Carolina's border. You go right over the border into Tennessee, that's where we are. You go right over the border from the whole North Carolina, South Carolina, North Junction, that's where our facility is. Right over the border in Virginia, that's where it is. And it is unfortunate because we would rather be here. But if you look at the trends of DEC and DEP over the last 5 and 10 years, and even what's getting ready to happen now, it decreases the competitiveness for our North Carolina facilities. We exist in a global market and we're competing globally. We compete within the confines of the southeastern United States. North Carolina is losing that battle. The incumbent is penalized here. The new code has the incentive. We take the tax dollars, we take the long-term investments that these companies have made in North Carolina, and we shift it to new code. Companies like ours, we have to go be a new code to another state.
All right, Mr. Heilig.
I'm sorry.
I appreciate I appreciate your testimony. It's helpful to our understanding of the large customers situation. You talked some about being incentivized to grow here versus growing elsewhere. And I assume when you all are making those decisions, electricity is one component of a sort of multi-component or multi-factor analysis that you engage in.
It is. So you really look at 3 legs of the stool for economic development. Energy is the largest for us. I mean, it's the biggest piece for us. We're energy intensive. So it's a big piece. There is no channel for Duke Energy to offer us incentive because we're not increasing load. Headcount's one thing. Duke Energy can't control headcount. The other is some infrastructure dollars that come through local counties or the state. But energy is the biggest piece for us. And there's no avenue for Duke Energy to offer us a new incentive rate for reinvestment. And we operate in rural communities. we're normally the largest, second or third largest employer in these rural communities. And, you know, these new big investments that the state of North Carolina is getting, and we're excited about, those are going to higher populated counties than where we normally operate.
Can you tell me where in DEP's service area your facilities are located?
So one DEP's in Lee County in Sanford, North Carolina.
Okay.
Yeah.
Okay.
And that's a large facility. In that facility, you know, it's a snowball effect, right? That facility supports primarily a large underwear brand based out of North Carolina also. So our competitiveness there means something to them. And, you know, their competitiveness means something to thousands and thousands of other employees. So it's a, you know, a snowball effect. But Park did, you know, again, takes an awful lot of pride of being a resident of the state of North Carolina.
All right. All right. Let me see. Let me start with Commissioner Duffley and then Clodfelter and then Kim Wright.
So as I heard your testimony, the economic development rider is not beneficial because you are not adding new load and you're not adding new jobs, and that you're seeking investment or incentive for reinvestment, modernizing your equipment to actually reduce load from, say, 12 megawatts to 10 megawatts. Do you know, are there any utilities across the country, anywhere else across the country, that provide those type of incentive rates to just modernize and stay within the state without tying it to jobs or adding new load?
So I need 1 minute of deferral to double check, but I do believe so. We have received incentive rates after initial investment through reinvestment in existing facilities. So yes, I do believe so, but I will say so with a 96% degree of confidence.
But you can't sit here today and tell me what state that is, or if
Tennessee.
you could. Tennessee. Okay, thank you.
And that's TVA.
TVA. Okay. Thank you. I don't have anything further.
But so there's twofold to that. One thing is I'm here today to talk about economic incentives. The one thing that I'd like to share and be real clear about is the proposed increases in DEP are why I'm here. And to me, the shocking increases that we'll see over the next 3 years are very concerning to me as an executive.
Okay, thank you.
Thank you.
All right, Commissioner Clodfelter.
I'd like to hear you say a bit more about what it is that tips the scale in Georgia and your ability to implement a behind the meter solution. Is it tax policy and tax incentives? Is it lower cost of the equipment and installation and labor in Georgia? Is it rate design and the utility tariff?
So
What tips the scale?
So I need to kind of clarify what we're doing in that Georgia had an opportunity that existed probably 8 years ago. It's not there today. So in other parts of the world, we're using solar to shed load during peak demand hours. What tips the scale is tax. It's always tax, right? The investment cost of solar is far too high for private investment. So when North Carolina opened some windows a number of years ago, we were an S Corp and our shareholder group didn't have the capacity at the time. We have since changed to a C Corp, but those windows haven't reopened. So we would be excited about seeing those opportunities come back where there's some assistance in that investment that allows us to shed load.
Thank you. So what it was 8 years ago in Georgia was tax driven, essentially.
Yeah, so different states throughout the Southeast have opened those windows from time to time, and we had a third party group that was involved.
And you were asked a question by CBIS Council about the GSA program, and you said that the GSA program doesn't fit your company's profile. And I don't want to know the specifics of why, but are you referring to the GSA program it's in existence. It was approved by the commission, I believe, in 2019? Or are you also referring to the proposed Green Source Advantage Choice Program that's pending before the commission? And again, I don't want to know the specifics, but are you referring to both or just the previously approved?
So it would be both for us. We haven't seen an advantage in either case.
Okay, thank you.
And thank you for recognizing I'm not an engineer. It gets a little bit above my head. I really enjoyed the first few pieces of testimony that I was in the room today. So I'm excited, and this is my first time testifying before you, but you know, we are a proud resident of North Carolina. We appreciate the work that you do. And we also appreciate the intent to help us stay competitive. We've employed thousands of people. We've put thousands of kids through college. We've built YMCAs. We've built rec centers. And we want to be here in the southeastern United States. We want to be in North Carolina. It is becoming a challenge.
All right. Thank you, Mr. Heilig. We appreciate your testimony and your being here with us. Let me see. Well, actually, let me see if there are questions on commissioners' questions. Mr. Freeman.
Thank you for coming. I guess I think of it as sort of being a scale of things that you consider where to make investments.
Yes.
Help us think of some things that could do to put their thumb on the scale and tip it towards North Carolina. Some incentives that you'd like to see, or just some thoughts that you might have.
Well, certainly investment incentives. You know, they're load-based or employment-based, and I certainly understand that. But there needs to be an incentive for a sustainable incentive, right? That encourages reinvestment for existing businesses to remain residents of the communities in which they operate. That doesn't exist today. We have 2 facilities in the state of North Carolina we have to reinvest in. And without a change, those will go to another state. We need those to be here because of federal law. So they'll be manufactured. We'll make those products here in the United States. If I'm guessing today, we're going to choose, you know, the next state, be it Alabama, Georgia, somewhere other than North Carolina. So how do we maintain that? And I think that we look at, we removed 34 megawatts of load in the state of North Carolina and built 43 megawatts of load outside of the state of North Carolina. And that's happened over the last 5 or 6 years. So we historically have been one of Duke Energy's largest customers. I don't know that we're in their top 5 or 10 today, but historically we have been. We'll continue to get smaller until the point that, you know, we can begin to add new load back into North Carolina or add headcount back into North Carolina. So to answer your question, a rate that somehow assists the incumbent to make reinvestments to have a sustainable long-term business. Did that answer that?
Thank you.
I tried.
It did. Did you participate in the load retention rider that was around a few years ago?
I'm assuming our engineering group looked into it and didn't find it. I don't know. Okay. I don't know of that rider in particular.
Thank you.
Thank you.
All right, Mr. Heilig, with that, we step down. Excuse power.
There were no exhibits.
Thank you for your time.
Thank you.
Public staff calls James McLawhorn and Dustin Best.
All right, good afternoon, gentlemen.
Good afternoon.
If you would, raise your right hands, left hand on the Bible. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right.
Okay, Mr. McLaughlin, I'll start with you. Please state your name, position, and business address for the record.
James McLaughlin. I'm the Director of the Public Staff's Energy Division, and I'm at 430 North Salisbury Street in Raleigh.
And did you cause to be pre-filed in this docket on or about March 27th, 2023, direct testimony and question and answer form consisting of 13 pages and one appendix?
Yes.
If I were to ask you those same questions today, would your answers be the same?
Yes.
And on May 4th, 2023, did you cause to be filed a summary of your pre-filed direct testimony?
Yes, that's correct.
Madam Chair, I request that Mr. McLaughlin's pre-filed direct testimony and summary be copied into the record as if given orally from the stand.
All right, the direct testimony filed by witness McLaughlin on March 27th, 2023, consisting of 13 pages and one appendix, will be copied into the record as if given orally from the stand. The summary to that testimony will be copied, the summary of that testimony will be copied into the record as if given orally from the stand as well.
Thank you. Mr. Metz, please state your name, position, and business address for the record.
My name is Dustin Metz. I'm an engineer with the public staff. My business address is 430 North Salisbury Street, Raleigh, North Carolina.
And did you cause to be pre-filed in this docket on or about March 27th, 2023, direct testimony and question and answer form consisting of 87 pages, one appendix, and two exhibits?
Yes.
And on May 4th, 2023, did you cause to be filed corrections to your pre-filed direct testimony?
Yes.
If I were to ask you those same questions today with the corrections incorporated, would your answers be the same?
Yes.
Also on May 4th, 2023, did you cause to be filed a summary of your pre-filed direct testimony?
Yes.
And on May 1st, 2023, did you cause to be pre-filed in this docket supplemental testimony in question and answer form consisting of 9 pages?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Okay, Madam Chair, I request that Mr. Metz's pre-filed direct testimony with corrections and his supplemental testimony and summary of his direct testimony be copied into the record as if given orally from the stand, and the 2 exhibits in his direct testimony be marked as filed.
All right, the direct testimony for witness Metz filed on March 27th, 2023, consisting of 87 pages and one appendix, is corrected by corrections filed on May 4th, 2023. Will be copied into the record as if given orally from the stand. The 2 exhibits to that direct testimony will be marked for identification as they were when pre-filed. The summary of that direct testimony provided by the witness on May 4th will be copied in the record as if given orally from the stand.
All right, thank you. And now together, did you both cause to be pre-filed in this docket on or about May 1st, 2023, direct settlement testimony in question and answer form consisting of 9 pages?
Yes.
Yes.
If I were to ask either of you those same questions today, would your answers be the same?
Yes.
Yes.
Madam Chair, at this time, I request that Mr. McLaughlin and Mr. Metz's pre-filed settlement testimony be copied into the record as if given orally from the stand.
All right, the supplemental testimony for witness Metz filed on May 1st, consisting of 9 pages, will be copied into the record as if given orally from the stand. The joint settlement testimony for witnesses McLaughlin and Metz filed in this docket on May 1st, 2023, consisting of 9 pages, will be copied into the record as if given orally from the stand.
All right, thank you. The witnesses are available for cross-examination.
All right. We will start with Sigber.
Thank you, Chair Mitchell. Good afternoon, Mr. Metz, and good afternoon, Mr. McLaughlin. Mr. Metz, we will start with you. If you could turn with me to page 30 of your direct testimony.
Page 30.
Yes, sir.
I'm there.
Do you see on lines 1 and 2, you say that from 2015 through 2022, the total present value of all non-fuel O&M costs declined year over year by approximately 3%?
That is correct.
And then you go on to say that notably, the fossil generating fleet O&M spend declined approximately 4% year over year, some of which resulted from capital project improvements.
That is correct.
Okay. Can you speak to how this interacts with the position that the company is taking on inflation and O&M spend in this rate case?
So addressing the one item, talking notably on lines 3 and 4 about some of the capital projects. I believe some of those projects are confidential in nature, so I won't go it so far, but the company makes capital investments overall to for a magnitude of things, but some of those result in either labor reductions or just natural O&M functions. One of the factors that were sort of discussed or listed here is saying notably between 2021 and 2022, the overall increase is relative, it's about 5.1% increase, which I believe to be a function of O&M. As Public Staff Accounting Panel recommended their overall adjustment for inflation, I believe this is also a known and measurable data point to potentially evaluate the actual inflationary pressures that incurred between 2021 and 2022. And I think what's also informative, if flipping to table 3, if you look at the overall total energy produced by megawatt hours in DEP, the relative amount between 2021 and 2022 are relatively static.
Thank you for that. Mr. McLaughlin, I will turn to you now if I could. If you could turn with me to Sigfur's binder that contains exhibit number 73, potential exhibit number 73, excuse me.
Sigfur 73. 73.
Yes, sir. And this is just for your reference, but it's a copy of Senate Bill 3, which the commission has already taken judicial notice of.
Okay.
And if you could turn with me to page 9.
Okay.
Mr. McLaughlin, are you familiar with the fact that Senate Bill 3 allowed non-fuel costs to be recovered through the fuel rider?
Yes.
And it was in this same piece of legislation, was it not, that the commission was given the authority to recover costs through the fuel rider on a rate other than a uniform cents per kilowatt hour basis?
Yes, up until the passage of Senate Bill 3, the fuel statute, as I'll refer to it, I believe used the word uniform. So the commission had approved fuel rates that were equal for all classes when they made the fuel adjustment. The change in Senate Bill 3 allowed the commission to consider non-uniform rates. It didn't require that they be non-uniform, but it gave the authority for the commission to approve non-uniform rates.
And so just to be clear, this happened simultaneously through the same piece of legislation that we've just talked about, both allowing recovery of non-fuel costs through the fuel rider and the ability to recover those costs on a non-uniform cents per kilowatt hour basis.
The costs that were allowed through the fuel rider were certainly expanded in this legislative change to include things other than just fuel. I don't know, I can't really say whether the change from the non-uniform from the uniform to the non-uniform had anything to do with the increase in categories of costs or not, but they were both in the same legislation.
Thank you. Is one of those costs that were expanded through Senate Bill 3 for recovery through the fuel rider include purchase power?
It included some costs associated with purchase power that were not fuel costs, yes.
And Mr. McLaughlin, you are familiar with the carbon plan that was adopted by commission order in late 2022?
Yes.
And you're familiar with the solar that was directed by the commission to be procured as a result of that order?
Yes.
So would you expect the amount of purchase power costs recovered through the fuel rider to increase over the rest of this decade?
So I believe the statute that 951 allows Duke to own, I think I've got the percentage right, 55% of new solar and third parties to build 45% of new solar. And so even the 45% will be a considerable increase in what we currently have. So I think it's safe to say that purchase power costs will increase over time.
And thank you for bringing up the 45-55 ownership split. It's correct, is it not, that the 45% of independent power producer owned solar will be recovered from ratepayers through the fuel rider?
I believe that's correct. I haven't gone back and looked, but I don't think there was any change to the fuel statute as a result of that. So I think you're correct, subject to check.
All right, Ms. Kress, I'll have you pause right there. We've come to our lunch break. We will be back on the record at 1:45. Let's go off the record, please. Record, please. All right, before we resume with the cross-examination of public staff witnesses, I'd like to take motions from council on to move in testimony for those witnesses that have been excused. So looking at this side of the room, I will ask, why don't we start with you, Mr. Smith?
Thank you, Chair Mitchell. And I've actually been asked to do this for more than just DOD FVA, but I'll start with DOD FVA because that's who I represent.
Right.
At this time, I'd like to move in DOD FVA Direct Exhibit 1, which is the direct testimony of Larry Blank, filed on March 27, 2023, that contains his testimony, which consists of 33 pages and 9 schedules and 2 exhibits.
All right. Hearing no objection to your motion, the testimony of DOD witness, the direct testimony of DOD witness Blank, filed in this docket on March 27th, 2023, consisting of 33 pages, will be copied into the record at the appropriate time as if given orally from the stand. The 9 exhibits to that testimony will be marked for identification as they were when pre-filed, and also admitted into the record at the appropriate time.
And just for clarification, it was 9 schedules and 2 exhibits.
I'm sorry. I stand corrected. 9 schedules and 2 exhibits to that testimony.
And I'd also like to move in DOD FEA Direct Exhibit 2, which is the direct testimony of Maureen Reno, filed on March 27th, 2023, which consists of 54 pages and an Appendix A and B, with Appendix B consisting of 9 exhibits.
All right, the direct testimony of DOD witness Reno, filed in the docket on March 27th, 2023, consisting of 54 pages, 2 appendices, and 9 exhibits, will be copied into the record as if given orally from the, as corrected on April 13th and April 27th of 2023. Will be copied into the record at the appropriate time as if given orally from the stand. Exhibits to that testimony will be marked for identification as they were when pre-filed, also accepted into the record at the appropriate time.
And I guess I'd ask for clarification. That was the next thing I was going to do, was move her errata in. Do I need to do that if you?
I've just done that.
Okay, thank you. I'd also like to move the summary of Larry Blank, filed on April 27th, 2023, into the record as well.
Let's do the summaries. Summary of the testimonies for DOD witnesses Blank and Reno will be copied into the record as if given orally from the stand at the appropriate time.
Thank you very much, Your Honor. Now, our Chair Mitchell, excuse me. I'd also like to take up Kroger and Harris Teeter's testimony.
Okay, please proceed.
Counsel for Kroger and Harris Teeter is in another hearing today and has asked that I move for the admission of Mr. Bieber's direct testimony in his absence. The commission has previously granted Kroger's motion to excuse Mr. Bieber.
All right, the direct testimony of Kroger and Harris Teeter witness Bieber, filed in this docket on March 27th, 2023, consisting of 23 pages and 2 exhibits, will be copied into the record as if given orally from the stand at the appropriate time. Those exhibits will be marked for identification as they were when pre-filed. The summary of the testimony for witness Bieber will also be copied into the record as if given orally from the stand at the appropriate time.
Thank you very much, Chair Mitchell. And finally, the commercial group also asked me to move the direct testimony of Stephen W. Chris, along with Appendix A, providing his experience, and 7 exhibits marked Chris Exhibits 1 through 7, as well as a summary of his testimony.
All right, the direct testimony for commercial group witness Chris, filed in this docket on March 27th, 2023, consisting of 32 pages and one appendix will be copied into the record as if given orally from the stand. The 7 exhibits to his testimony will be marked for identification as they were when pre-filed, also admitted into evidence at the appropriate time.
Thank you very much.
All right, Ms. Kress, would you like to move your testimony?
Yes, thank you,
Okay.
Chair Mitchell. At this time, Sigford 2 moves that the direct testimony filed in this docket on March 27th, 2023, on behalf of Sigford 2 witness Nicholas Phillips Jr., as corrected on May 10th, 2023, consisting of 19 pages of testimony and one appendix consisting of 3 pages, be entered into the record as if given orally from the stand at the appropriate time. And further, that the 4 exhibits attached to Sigford 2 witness Phillips pre-filed direct testimony filed in this docket be marked as pre-filed and entered into the record at the appropriate time.
All right, Ms. Kress, the direct testimony for witness Phillips filed in the docket on March 23rd, 2023, corrected on May 10th, 2023, consisting of 19 pages and one appendix, will be copied into the record at the appropriate time as if given orally from the stand. The 4 exhibits to that testimony will be marked for identification as they were when pre-filed, also admitted into evidence at the appropriate time.
Thank you. And next, Sigford 2 moves that the supplemental direct testimony in support of partial settlement as corrected on May 10th, 2023, which was originally filed in this docket on May 2nd, 2023, on behalf of witness Nicholas Phillips Jr., consisting of 7 pages of testimony, be entered into the record at the appropriate time.
All right, the supplemental testimony for witness Phillips filed in the docket on May 2nd, 2023, later corrected on May 10th, 2023, consisting of 7 pages, will be copied into the record at the appropriate time as if given orally from the stand.
Thank you.
And the summary to Mr. Phillips' testimony will also be copied into the record as if given orally from the stand at the appropriate time.
Thank you. And then finally, Sigford 2 moves that the pre-filed direct testimony of Sigford 2 witness Michael P. Gorman be entered into the record at the appropriate time, consisting of 62 pages of testimony, 1 appendix, and 7 exhibits.
Okay, the direct testimony of Sigford 2 witness Gorman filed in the docket on March 27th, 2023, consisting of 62 pages and 1 appendix, will be copied into the record as if given at the appropriate time, as if given orally from the stand. 7 exhibits will be marked for identification as they were when pre-filed, and will also admit those at the appropriate time.
Thank you.
All right. CUCA.
CUCA doesn't have any witnesses to move in. As I understand that Mr. O'Donnell's testimony was already adopted into the record.
Thank you. All right, let's see. NCJC.
Good afternoon, Chair Mitchell, David Neal for NCJC et al. At this time, we would move to have the direct testimony of Mark Ellis which was pre-filed on March 27th in this docket, consisting and is corrected on May 3rd, consisting of 152 pages and 3 exhibits, be entered into the record as if given orally from the stand, and his exhibits be marked as pre-filed and also entered into the record at the appropriate time.
All right, Mr. Neal, just I have it's 155 pages. I think you said 153.
As corrected, 152 as corrected
100
on May 3rd.
Okay.
And I should clarify that there's no confidential material in his corrected testimony.
Okay, thank you. All right, the direct testimony for NCJC et al. Witness Ellis filed in the docket on March 27th, 2023, later corrected on May 3rd, 2023, consisting of 152 pages. Will be copied in the record as if given at the appropriate time, as if given orally from the stand. The 3 exhibits to that testimony will be marked for identification as they were when pre-filed, also admitted at the appropriate time.
Also at this time, NCJC et al. Would move the direct testimony of David Hill and Jacob Duncan, which was pre-filed on March 27th and consists of 97 pages, be entered into the record as if given orally from the stand at the appropriate time, and that the 12 exhibits to their testimony be marked as pre-filed and entered the record at the appropriate time.
All right, that motion will be allowed, and the summary of the testimony for witnesses Hill and Duncan will also be copied into the record at the appropriate time, as if given orally from the stand. I also would like to note that the summary of the testimony for NCJC et al. Witness Ellis will be copied into the record at the appropriate time, as if given orally from the stand.
Thank you, Chair Mitchell. I was going to do all the summaries at the end because they are being filed, I think, as we speak, but
okay.
I appreciate that. Also at this time, NCJC et al. Would move the direct testimony of David Posner into the record as if given orally from the stand, which was filed on March 27th, consisting of 85 pages, which does contain confidential information, and that is one exhibit be pre-marked as identified in his testimony and entered into the record at the appropriate time, and that his summary also be moved into the record at the appropriate time.
All right, the direct testimony for NCJC et al. Witness Posner filed in the docket on March 27th, 2023, consisting of 85 pages, shall be copied into the record at the appropriate time as if given orally from the stand. The one exhibit to that testimony shall be marked for identification as it was so marked when pre-filed, and confidential portions of that testimony shall be reflected as confidential in the transcript. And the summary to that testimony will be copied into the record at the appropriate time as if given orally from the stand. Exhibits will be accepted at the appropriate time as well.
Thank you.
All right, let's see. Sierra Club.
Afternoon, Justin Smolowski on behalf of the Sierra Club. At this time, we'd like to move into the record the direct testimony of Michael Goggin, consisting of 31 pages and 10 exhibits, pre-filed on March 27th, 2023.
All right, the direct testimony for Sierra Club witness Goggin filed in the docket on March 27th, 2023, consisting of 31 pages, will be copied into the record as if given orally from the stand. The 10 exhibits to that testimony will be marked for identification as they were when pre-filed and admitted into evidence at the appropriate time. Summary to that testimony will be copied into the record as if given orally from the stand, also at the appropriate time.
Thank you.
And witness Colton.
Mr. Colton is present. Wasn't excused.
Okay. Okay. All right, Mr. West.
Thank you. I'm James West of the Fayetteville Public Works Commission. I would like to move into evidence and have copied into the record at the appropriate time pre-filed direct testimony of Lori Tomczyk, consisting of 44 pages and 3 exhibits, as corrected by the testimony and exhibit corrections filed in docket number E-2 sub 1300A on April 13th, 2023. And the summary of witness Tomczyk that was filed in the same docket on May 1st, 2023.
All right, Mr. West, your motion will be allowed, and just note that the confidential portions of her testimony will be reflected as confidential in the transcript.
Thank you, Madam Chair.
Chair Mitchell, it's come to my attention that I did not move in Mr. Gorman's summary.
All right, Ms. Kress, we will have Mr. Gorman's testimony summary copied into the record at the appropriate time as if given orally from the stand.
Thank you.
All right, let's see. Anyone from the League of Municipalities here? All right, we'll have that testimony moved in at a later time. Mr. Moore, do you want to move in your testimony at this time? Oh, I'm sorry. That's right. I'm sorry. Excuse me. Okay. All right. Any additional procedural items to be addressed before we resume with cross-examination?
Chair Mitchell, I don't know if you want to move in some of the public staff witnesses who've already been excused.
Let's hold on that, and we'll do that, Mr. Josie, when you all are through your witnesses that have not been excused.
Thank you.
Just remind me when we get to that point. Okay, with that, let's continue on. Ms. Kress?
Thank you, Chair Mitchell. Mr. McLaughlin, I'm going to show you what's been previously marked and entered into the record as SIGFR 2 cross-examination, Bateman and Stillman direct and settlement exhibit 3. And this was pre-marked as SIGFR 2 potential cross-exhibit 47.
Excuse me, 47.
Yes, sir.
I've got it.
Great, thank you. Can you please turn to the response to that data request on the next page?
I'm there.
Great. You were testifying before lunch about the expected impacts to the non-fuel component of costs to be recovered through the fuel rider, specifically power purchased from independent power producers to satisfy the 45-55% ownership split set forth in House Bill 951 and the Carbon Plan, correct?
Yes, I remember that.
And currently, you would agree with me, would you not, that the renewables and qualifying facilities purchased power capacity is a relatively small percentage of total costs recovered through the fuel rider?
Looking at the table that follows the response of that DR, I see on line 2, it lists renewable and qualifying facilities purchase power capacity. And I would agree that that is a smaller portion than the fuel and other fuel-related costs.
Thank you. But you testified before lunch that you anticipate the amount of purchase power costs recovered through the fuel rider to increase as the carbon plan is implemented. Has the public staff studied or attempted to quantify the expected impacts to the total costs to be recovered through the fuel rider as a result of carbon plan implementation?
Of the renewables and purchase power portion. I have not conducted such an analysis. I don't know if Mr. Metz is.
No, only thing, very high level at summary through the carbon plan was just looking at the PBR impacts and overall the carbon plan, no dedicated study.
Thank you. And Mr. McLaughlin, PPA costs are fixed costs, correct?
PPA costs or fixed costs? No, not entirely, because they're recovered in most cases on the basis of energy produced by the facility, maybe not exclusively, but significant portion.
Thank you for that. You anticipated a couple questions down. So, Mr. McLaughlin, is it true that the equal percentage increase or decrease method is based on an average monthly bill per rate class methodology such that each rate class will, on average, experience the same average monthly bill increase?
Let me start out by saying I am not the public staff witness on this subject matter. That's Mr. Lucas, who will be appearing later. So I would defer any specific questions on that to him, but I would agree that it is based on an equal percentage change to the total revenues for the class.
Thank you. Would you agree with me that the fuel rider proceeding is an abbreviated cost recovery mechanism?
It only considers the cost of fuel and fuel-related costs. So yeah, it is a cost recovery proceeding, and that is the one thing it covers.
Would you agree that a general rate case allows costs to be examined much more thoroughly than an annual rider proceeding?
it certainly allows a broader look at all costs. Yes.
You were involved in the cost of service stakeholder group that preceded this rate case and served as the jumping off point for conversations that culminated in a cost of service partial settlement filed in this case, correct?
Correct.
And you were also involved in the comprehensive rate design study.
To a lesser extent, but yes.
Thank you. And would you agree that those stakeholder processes provided an opportunity for parties to work through some otherwise very contentious issues?
That was the intent, and I believe that was the result, yes.
And did those forums provide an opportunity for parties to have constructive dialogue that culminated in many of the very recommendations pending before this commission as part of this general rate case?
Could you repeat the first part of your question?
Sure. Did those forums, the stakeholder processes that you were just testifying about, provide an opportunity for the parties to have constructive dialogue that culminated in many of the recommendations pending before the commission as part of this general rate case?
Yeah, the public staff believes that the dialogue was constructive, and we appreciate the parties that participated, and I believe that the parties that did participate participated in good faith.
Thank you. At any point in time during either the cost of service stakeholder process or the comprehensive rate design study, did the public staff raise the fuel rider allocation methodology as a topic to be studied or discussed?
I honestly do not recall if it was or was not. I did not raise it, but I don't recall.
Thank you. Mr. McLaughlin, did you hear some discussion yesterday afternoon regarding risks to ratepayers associated with PBR and MYRP?
Yes.
Okay. Can you talk a little bit about the workload associated with the first MYRP general rate case for DEP and how that compared to past general rate cases without a multi-year rate plan?
I will be happy to after I heard Ms. Bateman, witness Bateman, and she had made notes on that. So I thought maybe I should go back and make some notes. So I have a few, but yes, HB 951 in particular significantly increased the workload of the public staff, as I know it did the commission and many other parties, and we were not given any corresponding resources to handle that. So in investigating this first of a kind rate case, I mean, what we realized pretty early on was that we were essentially being asked to investigate 4 rate cases at one time instead of the normal one. And we were given only an additional 30 days to conduct that investigation. So we had to make decisions during our investigation as to how to proceed. And I heard Commissioner McKissick yesterday say he was pleased to hear about the review that the public staff was able to accomplish, particularly with respect to the MYRP projects. And I am very proud of the review that we were able to do. However, we did have to curb our review in some areas, particularly in the base case portion, and Mr. Metz could shed more light on that, but we were not able to be as thorough as we typically are just due to time constraints, not only in this case, but all of the other pending matters that I know the commission is aware of. I mean, we've been investigating the DEC rate case at the same time. DEC filed 4 rider proceedings that we just filed testimony on earlier this week. One of those, the fuel case, had an unprecedented almost $1 billion under recovery and numerous
plant outages that we have tried to investigate. Of course, at the beginning of this case, the accounting division was still investigating 2 water MYRP cases. There have been the refinement of the rules for the CPIRP proceeding that we've had. There have been numerous stakeholder proceedings that we're required to participate in, and any number of other matters, and not the least of which, as I would like to remind the commission, we initiated through the commission's assistance an investigation into the Winter Storm Elliott events, which we have had to put on hold at least until we can get through this rate case. So we've not been able to make a lot of progress on that beyond receiving some data responses. So yes, it has been very challenging. Mr. Metz, if you want to add to that.
Some of the challenges were listed in the testimony. I mean, we acknowledge it's the first of a kind and lessons learned. To elaborate a little bit more, what Mr. Maloney was saying on the trade of what we had to potentially pull back from our usual investigation in a general rate case. I can just try to be a little bit illustrative as a hypothetical example is typically when we start our sample of plant-related items, we send out general discoveries. So let's just say you start with 100 projects under hypothetical, even though there's hundreds upon hundreds. You sample, let's just say 10 to 15%, and you send detailed discovery out on those, and you start reviewing the background material. You start looking at the need, you start looking at the costs, the timing, the project documentation, etc. And sometimes you have more questions on that subset. So you start at 100, let's just say you get down to 10, then you'll probably land about 2 or 3 where you really have more questions. One of the items of sacrifice was typically if you find something at that later stage, you almost go back up to the beginning and say, okay, what commonality did those projects have, and is it wide scale? And I'm not alleging that it is wide scale, but just from an auditing standpoint, we were limited to do the sort of that restart to go back through the list as we traditionally do, because we were also had time constraints or resource constraints while also going through the MYRP.
And if I could add just one more thing that I failed to mention, and this is really a tip of the hat to my staff in the energy division who I manage. I asked them to go back and tally the amount of overtime they have worked just on the DEP case. And our division alone has had over 1,000 hours of overtime. And I'm sure Ms. Boswell will be able to tell you that the accounting division has probably worked many more hours than that of overtime. So
Just pertaining to the
just pertaining to the DEP case.
Thank you for that. And so you mentioned, having 30 additional days and having constrained resources given the press of other business. Does that put ratepayers at increased risk when the public staff is not able to do as thorough of an audit as it would have in a traditional general rate case?
Well, and like I said at the beginning, I am very proud of the work we've been able to do. And I think we have done a thorough audit, but certainly if we had more time or resources, we could have done more.
Thank you.
And if I can add one thing, the complexities of some of the items that we're investigating are new as the grid's transitioning, or some of the investments are taking place, which Duke had identified, and we've had multiple discussions throughout. They're not necessarily the same as they were a decade ago or 2 decades ago. So the magnitude of projects and total costs are amplifying some of these constraints that we're talking about.
And certainly in the DEC case, which will come later, we have learned things early in the process of the DEP case, which we will be able to apply that maybe don't show up here because we ran out of time. But that's just sort of the way it goes when you have a finite
end to a project. So.
Thank you. No further questions.
Matt Tynenberg, CUCA. Mr. McLaughlin, you mentioned that in your testimony that and here today that the public staff wasn't able to complete the normal audit process that it would do. Is that right?
We completed the process. I think we weren't able to delve as deeply as maybe we normally would. We followed a similar process.
And if I can add one point of clarification from earlier statement, the items I was referencing sort of starting at that larger level and going down, I'm just speaking for the plant-related items. I'm not speaking directly to what the accounting panel and their overall process was.
And did the public staff take any time since your direct testimony was filed on March 27th to complete further examination of Duke's filing?
Well, and I think it's been chronicled. We filed supplemental testimony already, and I believe the March numbers, we're still investigating that. I just wanted to add, I mean, at some point, you know, as we like to say, it had to be pencils down. We had to file our testimony by a certain date, and we had to stop. Engineering had to give accounting our adjustments. They had to run the numbers, and we had to write testimony. And that, you know, that doesn't happen in 2 or 3 days. That takes a while. So we have continued to review, and I'll let Mr. Metz add some additional light on that. But, you know, then we had to prepare for this hearing, and we've been down here a lot. So that has interrupted a lot of our time, but go ahead.
And then for context, so again, listening sort of what's in my testimony is saying when we filed our initial testimony, it was based upon information filed on the specific date. As the company continues to update, which are allowed to update through the close of the hearing, we continue to evaluate those potential project costs on those updates. So, for example, my supplemental testimony addressed the new information that I believe was the December, January, and February. As the commission's well aware of, the third supplemental filed in March, that bucket of costs are still being reviewed. Initial discovery has been sent. Some more discovery will likely be spent to give context of timing. So when discovery is sent, it usually takes, if discovery comes back and it's complete and it's filed on time, take approximately 2 weeks from the date that we send it out. We will likely need to, or we started at that 100 projects, we get down to the 10. Now we're looking at a smaller subset. It'll probably take approximately, from initial testimony, about condensed about 4 weeks. If 4 to 6 weeks for engineering to complete its review, engineering needs to complete its review, have meetings and conversations with the company to ensure what we're seeing to the extent that we can. Have that information to accounting. Accounting understands those respective cost changes, if any. And then that information needs to go to legal and through testimony. And it does take a process to get through. But to answer immediate question is, we're not evaluating items. For items closed to plant, we're not continuing to evaluate items February pre. The items that we're now evaluating are the items closed in the month of March 2023.
Thank you. And in the partial settlement that the public staff reached with Duke, did it include any protections for the sort of incompleteness of the review of Duke's proposed projects?
I'm not exactly sure what you mean.
So the public staff is still reviewing the projects that are going to be part of that are part of this rate case.
Yeah.
Is that right?
Yes.
And in the stipulation and partial settlement reached with Duke, did the public staff include any protections regarding the projects that haven't been evaluated yet?
Well, we will file additional testimony updating the commission on that once we've completed it.
The part of the That partial stipulation does not include the capital projects up for cost recovery in March. Those items are still under review and not part of the revenue requirement.
Right.
Those are all the questions I have. Thank you.
Good afternoon, David Neal with, for NCJC et al. Good afternoon, gentlemen.
Good afternoon.
I believe my questions are for you, Mr. Metz. I want to walk through some of the concerns that you expressed in your direct testimony about DEP's multi-year rate plan application, particularly with regard to the distribution transmission plans. So first, if we turn to page 34 of your direct testimony, at the bottom of the page, you'll see a question about your recommendations in this general rate case based on your observations and trends of historic generating unit reliability. See that question at line 6 and 7?
Yes, page 34, starting at line 6.
And the last sentence of that response is that you request the company to address in its rebuttal some additional topics. So if we turn to the next page, could you read the second bullet there?
Page 35, starting at line 5. The company's spending priorities among business groups and MYRP, given decreasing SAIDI numbers, positive reinforcer from 2017 to present, concurrent with the negative trends in coal and natural gas generating unit performance.
Thank you. And first, decreasing SAIDI, that's an indication of improving reliability, isn't that right?
That is correct.
And you would agree that in DEP's case, the cost benefit approach that they used for distribution grid spending projects is based primarily on the expected benefits of reduced outages from improved reliability. Isn't that right?
So just want to make sure I characterize it correctly. So when we reviewed the overall MYRP projects, the public staff sort of assigned SMEs to each individual topic. Mr. Thomas was the primary SME for the distribution. So I don't want to counter his detailed review. I did work concurrently with Mr. Thomas. We did have multiple discussions. I know notably on the distribution, and this is a compliment for Duke, the linear optimization that they did do for the distribution was a very well put together analysis. But yes, based upon my understanding of that analysis, the benefits were based upon the reduction of outage minutes, and there might have been a couple other qualifiers that I can't recall.
And just to break down, when you say on page 36, line 5, when you're talking about spending priorities among business groups, and you're talking about decreasing SAIDI numbers, again, which relates to improving reliability, am I correct in the subtext there is you're saying maybe they're spending too much on the distribution grid in relationship to O&M for generating units?
That was part of my overall conclusion that I wasn't able to find or deduce where the company optimized across all the different business units. It doesn't mean what the company did was incorrect per se. I was just unable to determine to say where was, in very simplified language, what was the best bang for your buck for the overall ratepayer. It didn't mean what they did was wrong. It just, the appearance was that certain investments were done per business group, and they may have been done somewhat in isolation of one another.
Turning your attention to page 49 of your direct, lines 1 through 6, where you give your general impression of Duke Energy Progress's multi-year rate plan. Could you read your answer at 2 through 6?
So on page 49, starting on line 2, DEP's proposal has several broad issues that could impede successful implementation of the MYRP to the detriment of ratepayers, including inadequate staffing, lack of company-wide project optimization, inability to adapt to the changing conditions given the timing of the MYRP projects, and the likelihood of cost attributable to projects not currently in the plan.
Thank you. And then turning to page 50, lines like 10 through 19, would it be fair to say here you recount some of the difficulties you encountered in reviewing the application that you discussed previously in questions from Ms. Kress?
If I can have a
Sure.
few seconds to review. Yes, I believe those were some of the issues that I was talking about with answers to Ms. Kress's questions.
So for example, when you testified, essentially that your review is hampered because of DEP's quote, incomplete project support and project support documents not aligning with the company's work papers used to calculate rates. Do you see that at 12 through 15?
Yes, that did occur in the beginning. It take multiple conversations with Duke, but I believe that we ultimately landed in a better spot than we did when we originally filed, noting that again this was first of a kind, and it did enable a more thorough review of the NYRP projects once we had that documentation.
Then if you could turn with me to page 51 in response to a question at line 7 about the reconciliation process. You testified about project estimates here again at line 11. The project estimates were, quote, relatively old and likely outdated. For example, certain projects had estimates that were multiple years old, and initial funding requests, project funding approvals or equivalent, were completed in spring of 2022, nearly 6 months before the filing of the MYRP application. Do you see that?
Yes.
And are those concerns you still have?
Those concerns I can still have, but like to add context maybe to the elements that were the multiple years old, while I still believe it's a valid concern, some project estimates would be or could be old. And for example, again, trying to use a hypothetical that if I had a generation plant, and I was running that generation plant, I would have large degree of projects that always need to be implemented. Again, speaking from an engineer, it's a parking lot of projects. Engineers always want to solve issues, and it's up to someone else to say, this is what we're spending this year, which is a good thing. So some of the items that we identified that were in this parking lot per se, and they were relatively old, were projects that appeared to have been in that parking lot, sort of just hanging out, waiting for the opportunity. It could have just been a unique set of changing circumstances that elevated the project to go in. And just maybe it was just time for that project given natural changes in generation fleet or in the generating unit.
You would agree that there's been a lot of testimony in this hearing about inflation pressures affecting cost estimates, correct?
Correct.
So one of the concerns I assume that you would have had, and correct me if I'm wrong, is that a stale cost estimate might not reflect current prices. Isn't that right?
That would be correct, and that gets sort of the challenges of also when you look at elements as part of a cost benefit analysis, to the extent that the project in itself was based upon benefits that in order to implement the project, it needed the benefits in order to justify it, to the extent that if stale numbers were used, then yes, it could potentially challenge the validity of the overall analysis.
Turning now to page 55, near the bottom, starting at line 16. You would agree it's your testimony that your greatest concern with DEP's multi-year rate plan is the ability to meet necessary staffing levels to complete its proposed multi-year rate plan projects. Correct?
Correct.
And you would agree in the pages that follow, you include even some graphs that show a fairly steep line of increased staffing that would be required for transmission and distribution in particular. For example, on page 58, you have a chart for the distribution group that shows starting in second quarter 2022 two, I think, a pretty steep line of increased staffing required. Is that right?
That's right, but again, in fairness and context, on page 56, footnote 44, upon further review of the discovery, the responses to DR6, I'm paraphrasing here, it looks like we asked information in a certain way, but then we got information where they consolidated the business units, so that, one, that challenged the discovery process, but two, it this doesn't reflect reality. However, the company did clarify these labor staffing graphs in rebuttal testimony, if subject to check.
And then, well, at least at the time of your direct on page 60, lines 1 through 5, you recounted some of the back and forth on discovery and meetings with the company. And if you could read your testimony line, the sentence that starts on line 3 to line 5.
So page 60, starting at line 3. Overall, I found the responses regarding the increased staffing of the transmission business group to be the most uninformative. For my view, the company does not have a plan to increase staffing for planned MYRP work while continuing to perform traditional work other than rely on the outside market.
And here you said the transmission business group was the most uninformative, but it's fair to say from your testimony you also had concerns about the distribution group, isn't that right?
There were concerns about the distribution group, and again, I defer to Mr. Thomas on this particular topic, but from my view, the one key difference between the distribution group and the transmission group, there was a metric to evaluate the distribution group, and while the metric it did identify the shortfall, it was a marginal shortfall or sub 5%, but I defer to Mr. Thomas on that one, whereas the transmission group, I was unable to determine the plan other than heavy reliance on the outside market.
And then turning to, there's a question at the bottom of that page about the overall capital spend in the MYRP. And if we continue on to page 61, it's fair to say here you express some concerns with the total capital spending plan on a monthly basis. That if I read this correctly, lines 3 through 5, the company's proposed MYRP capital projects plus non-MYRP capital related work total $225 million per month compared to the base case of $112 million as discussed previously. Do you still have those concerns?
Yes, my overall observation, I did update these values and supplemental with the additional items closed in December through February. However, the rough level of magnitude is that, yes, with the inclusion of MYRP and non-MYRP over the next 3 years appears to be doubling the amount of capital spend than we have traditionally seen.
And again, this may have been updated, but it's table 8 on page 64 includes those numbers as they existed when you filed your direct for distribution, where it shows 1.8. And again, tell me if that is that $1.8 billion for distribution?
And the MYRP CapEx at
Yeah.
1.8 billion.
And then for non-MYRP, it's roughly 2 billion.
That is correct.
And I believe, were you here for witness Bateman's testimony?
I was here, but might need to refresh my memory of the exact part.
Well, I heard her testify, and if you didn't, that's fine, that that there was an issue around, I think her testimony was to the effect of in the next rate case, they won't have the same kind of catch up as was seen in this rate case. Do you remember her testimony about that?
Generally, yes.
And you would agree that capital spending that's not in MYRP is going to show up in a future general rate case, isn't that right?
That's correct.
Now, if we could move to page 69. this is, I think, where you're, if I remember correctly, you kind of sum up some of the things we're talking about. So if you could, for me, read your testimony starting at line 2 on page 69.
Starting with the sentence, in addition.
Yes.
Page 69, line 2. In addition, it has not identified any equipment necessary to carry out its MYRP that takes longer than 6 months to procure or cost over $150,000. It has not developed projections of the staffing or equipment that we needed, and has not assessed the risk for MYRP projects to fail to achieve the project in service dates. Nevertheless, the company denotes portion of these discovery requests as premature and expresses confidence that it will complete the projects, pointing out the Commission's rules allowing the company to modify or adjust projects as it deems necessary.
And then could you read the next sentence starting at line 11?
I do not have the same confidence as the company that the projects in each rate year can be completed. I understand that the MORP is a forecast and projections change over time. How far do you want me to go?
So you testify next that the company appears not to have begun some of the actions that you think are necessary to implement those projects. And again, the information, the lack of information that you would need to perform an analysis of those projects. And if you could read the sentence that starts on line 17 through 19.
And MYRP should not be a blank check for the company to do as it determines without any oversight.
And then I think this is the last part of your testimony. I have you read the line 20, the concluding sentence there.
But the company should have enough information for analysis of whether there is a need for the project and whether the company has the ability to complete it, including the cost, staffing, timelines, as well as the risk analysis. And then going a little bit further on that is a large effort of the public staff's review and the MRP was tying it at a minimum to the need, which we established in the projects we identified. It was laid out forth in the testimony. The compounding challenge was the overall ability, which is noted out through my testimony.
So again, we've just gone over a high level some of the concerns that you had with the company's multi-year rate plan application. But you would agree the public staff has not recommended that the commission reject the multi-year rate plan, has it?
Public staff did not reject MRP, did not recommend the MRP to be rejected.
And public staff has not recommended that DEP scale back any of the distribution capital spending that is either inside or outside the MYRP. Outside of, I think, let me take a step back before I ask that question. I got ahead of myself. As I understand it, public staff did challenge 47 out of the 297 distribution MYRP projects. Is that right?
Subject to check.
But outside of those specific challenged projects, the public staff has not recommended that DEP scale back or slow down on any of its planned distribution capital spending in the MYRP.
That is correct.
And no further questions. Thank you.
All right, DP.
Just a few questions for you, primarily for witness Metz. So counsel for NCJC just walked you through some of the concerns that you had articulated in your testimony. You recall those questions?
Yes.
And the concerns that, some of the concerns that you just touched on were concerns related to project documentation, correct?
Correct.
The cost estimation provided by the company, and then staffing are kind of the three key things we covered.
Very high level, yes.
And you're aware, are you not, that the company witnesses responded to many of your concerns in rebuttal testimony, correct?
Yes, they did.
Okay. And the company witnesses also acknowledged the unique challenges of a first of its kind PBR rate case.
That's correct.
And expressed appreciation for the depth of public staff's review.
Yes.
Speaking specifically to the cost estimating process, would you agree that through the course of the PBR process, the company and the public staff came to an agreement on the criteria by which certain of the MYRP project cost estimates would be updated at a certain point in the case.
Yes, that is correct. And it is noteworthy that it was a beneficial conversations that we did have the utility to address the public staff's concerns of the stale estimates and agree on criteria of which we can update without necessarily needing to redo an entire MYRP case. As I noted earlier in my testimony, it's approximately $4 billion spend. It takes time to compile that information, and trying to find that sweet spot of saying how much time does Duke need to compile that case and not have stale estimates for the public staff to pick it up and start running. There could be tension between those 2 points. And we did try to work together to try to resolve those issues.
And would you agree that the arrangement that was developed, that set of criteria that would guide what costs would be estimated, was a reasonable approach to this challenging but important issue?
Absolutely, yes.
Okay. And so the company did in fact provide updated cost estimates in accordance with that criteria, correct?
That is correct.
And it's those updated cost estimates combined with the estimates that were not necessarily deemed necessary to be updated. It was that set of information upon which public staff ultimately reached its conclusions in this case.
That is correct. And the projects are ultimately agreed upon for settlement, yes.
And yes, and that also guided the decisions the public staff made in terms of what it agreed to support in the settlement, as well as the issues it chose to leave as unresolved issues in the settlement.
That is correct.
And just for the clarity of the record, in terms of the partial revenue requirement settlement, the company did accept certain of your recommended changes to the costs, to the revenue requirements resulting from the MYRP projects, correct?
That is correct.
Okay. And others of the recommendations that you made with respect to the MYRP projects were not accepted as part of the give and take of settlement, correct?
As far as give and take of the overall settlement, yes, I agree.
But would you say, but based on the entirety of the in-depth examination that public staff was able to perform during this case with respect to the MYRP, you believe, do you not, that the settlement represents a reasonable compromise of issues related to the capital projects in the MYRP?
Yes, I do.
I have no further questions.
All right, redirect.
A few questions. Mr. McLaughlin, I'm going to start with you. You and Ms. Kress had a discussion about modifications to the fuel statute that came about in SB3. Do you recall that?
Yes.
And did customers have to pay for renewable energy or cogeneration energy prior to those modifications to the fuel statute? And the modifications I'm talking about are adding what you consider non-fuel related costs to the fuel statute.
Yes, the cost other than fuel itself prior to the SB3 changes were recovered through base rates. So they were paid, they just weren't paid through the fuel statute.
And she also asked you about HB 951 and the power purchase costs that will be recovered through fuel rider. Do you remember that?
I do.
And isn't it true that the assumption is that when we implement the carbon plan, and Duke is required to make more of those power purchases from renewable energy, that the actual fuel costs from coal and natural gas should go down?
Yes, that is the expectation. Certainly, under the current plan, we will retire all of the coal plants, so we won't have any coal-related cost at some point in the future. And Mr. Metz can add more color to this, but even though we will maintain a significant portfolio of gas plants, the projection is that those plants will run much less than they do today. So we will have, I don't know what the gas cost will be then, but we will have a reduction in the quantity of gas burned.
I agree.
And Ms. Kress also asked you about discussions or whether discussions of the equal percentage allocation was brought up in various stakeholder groups, correct?
She did ask me that.
And understanding you are not the designated witness on the public staff's position on the fuels equal percentage allocations, can you discuss the general timeline of the public staff coming to its position on this equal percentage in this case?
It was as this rate case progressed and we focused more on the specific language in HB 951 and what it required as it relates not to the carbon plan, but to the PBR and the multi-year rate case, what that specific language said. And I think Mr. Lucas addresses, well, I know he addresses this in his testimony, but it has to do with the, limiting or minimizing cross subsidization.
And did the public staff alert SIGFUR that it would be recommending this change prior to filing its testimony in this case?
We did. We alerted both SIGFUR and CUCA because we knew they were parties to the original stipulation back in 2008, and we did not want them to feel that they were blindsided by a recommendation when we filed our testimony.
And Mr. Metz, you just had a conversation with Mr. Chirac on the MYRP update that Duke Energy or DEP filed in this case, correct?
Correct.
And do you agree that through this process, the public staff had learned a lot of lessons or gained a lot of information and lessons based off of going through the first of its kind rate case?
Yes.
And would you agree that everything done in this case isn't necessarily how things should be done going into the next rate case?
That's correct. Hopefully we can leverage lessons learned and modify a few things around the edges to leverage efficiencies.
Thank you. No further questions.
All right, I will see if there are questions from commissioners. Commissioner Brown Bland. Okay, Commissioner Clodfelter.
Thank you, Madam Chair. Mr. Metz, I had a number of questions for you, some of which have been covered in the examination by counsel, and so I'll try to avoid repeating the best I can. First of all, I want you to focus on the particular CapEx, plant CapEx that's addressed in the stipulation. That would include generation, transmission, and distribution. With respect to those specific project items that got called out and addressed in the stipulation itself, would I be safe to assume that the ongoing review that the public staff is doing of the supplemental information filed by DEP is not going to affect any of those items?
That's correct. The MYRP is now in a box. The box is locked.
Got it. On those projects, it's locked.
Yes, sir.
And so your ongoing review that you've begun through discovery and that you will follow the process that you outlined in your response to council, that's relating to matters that were closed to plant and service after February.
That is correct. That is what we traditionally call the base case or the historic rate case.
Does it cover anything else other than that?
It does not touch the MYRP.
Okay, great.
But let me add one caveat. To the extent that a revenue requirement is calculated, it will feed into the overall calculations and the 4% test, but the projects in MYRP are no longer being touched.
Thank you for that clarification. I'm really focused on the projects themselves. Thank you. Okay. You were asked a number of questions, primarily by Mr. Neal, about some of the concerns that you expressed in your original testimony, and I'm not going to rehash all of the litany of all of those, because my question really is not sort of going through each of the concerns you expressed. But what I want you to talk to me about is is what are the things that I should look to in the stipulation that you believe speak to those concerns? And the two I'm particularly want to focus you on are the concerns you expressed about system reliability on an ongoing basis and the trends relating to system reliability. And then your concern about optimization of projects across the different business units at DEP. Are there things that I should pay special attention to in the stipulation and give weight to that speak to those concerns? And if so, how do you think they address those concerns?
And for a point of clarification, that we are talking not just about the MYRP, we're also talking about other items. For example, I'm going a little bit off here, but the coal reliability O&M aspect of it, while technically it's not part of the MYRP, it is part of the settlement. I just wanted clarification on where you're trying to keep me in the bounds.
Well, I actually don't want to keep you in too much bounds. I had a separate question about the coal unit O&M reliability. I'll ask it separately, but if you want to package it together, again, the gist of what I'm asking you is tell me what are the things in the stipulation that I should hold on to and say, aha, this is going to help me understand how we're going to deal with the concerns expressed by witness Metz.
Understand.
Okay. You can speak as broadly as you believe appropriate.
I'll try to keep it truncated and on point. So maybe isolating general categories, so looking at general plan. The overall investments, again, speaking generally, for the MYRP are traditional items that need to be completed, just general maintenance that needs to maintain the plants, whether it's nuclear, coal, natural gas, et cetera. The other items that I believe that we're talking about, notably that helps with continued reliability and a changing landscape with generation assets, was the advanced gas path inspections that were enabling future opportunity. And if I could dovetail this further into, say, one of your earlier questions in the hearing was about projects close the plant from March to September, which is pre-rate year one. One of those projects happened to be, it is the advanced gas path inspection or process for Smith unit. And to clarify that further, that period between March and September pre-rate year one, for DEP, it's only 27 million. So DEC is larger. That's a different case. We can talk about that much later in a few months. But for DEP, it's only $27 million of capital projects within what I designate as this gray period prior to the start of rate year one.
Well, I'm sorry to interrupt you, but tell me how that project feeds into the general question I asked you. What is it about that project that sort of gives me comfort?
That overall project will increase efficiencies, so use the fuel better, less overall cost for ratepayers going forward through the general fuel rider. It provides increased unit flexibility with system ramping, so we can respond better to intermittency or either just need general ramping or load conditions that change, and an ongoing investment to just maintain the overall turbine, which is a sound investment just in itself. So you're going to have to do this work anyway, simplifying. For an incremental amount, you had these extra benefits that came with it. So I believe the advanced gas path inspection is a very positive thing for ratepayers. Focusing back a little bit to the coal plants, which I focused in with all my testimony. I identified to say we traditionally spent X through the MYRP, that we are spending less than. It doesn't mean that the company will not spend what we traditionally spend. It's just what got identified. So based upon our review, multiple discussions with the company, then the company made their initial applications and they had projects for coal, and we were evaluating those projects and just challenging the company, like, why are these in here? What's the basis of need? Show us your run time, show us your trending statistics. et cetera, noting that when they filed the MYRP, it was based upon a snapshot in time at that point. So through discussions, the company said, yes, we are going to be, the priority of projects need to occur. So they went to the parking lot and said, all right, the project's very isolated, a handful of projects that were identified. We're going to put those back in the parking lot, and we're going to pull in other projects that seem to be escalated based upon need. And the public staff didn't find any concerns with those additional projects that got pulled back into MYRP because those were typical or standard investments needed to maintain overall system reliability for those generation assets. Switching over to distribution, I'm going to overgeneralize a statement. Some of the investments are just based upon aging infrastructure. I mean, based upon our review, please don't ask me for the exact substation or transformer or switching device, because there's been many that we've reviewed, but some of these are just, they're at the end of their life. These were going to naturally occur. Duke trends those projects and identified it says, hey, we have a project need. What else can we do while we're doing that level of work that went into some of the different additional programs they identified where it can have increased system reliability. So either whether it's the overall tug or whether it is the sort of the self-healing grid or the SOG. For more specific questions on distribution, I really need to defer to Mr. Thomas before I get too far ahead of my skis. Transmission was the same way. It's very similar to distribution. Core assets on our generation plant are just aging out. That's just part of the life cycle. So those investments were being made to replace those and bring them up to today's standard, as the commission's very well. I mean, changing NERC standards, mostly cybersecurity and physical security. Those are target investments that I believe are critical to maintain system reliability in the overall system. And keep going, but that's a very good snapshot.
Well, you've in the course of your answer, you've touched on a couple of other things I wanted to ask you about, but if you've got more to say, that's fine. I want to know where I go in the stipulation for my security blanket on the topics that you're addressing. And if there's anything else that you want to offer up, go ahead and do it. If not, I'll move to some other questions.
Pivoting back to trying to come full circle, it's some of the challenges that we had is it's timing. So again, we established for the most part need, but it was the timing, and it gets into more of what certainty does the public staff have, representing the general consuming public, that we can actually complete those projects in that time frame. Should it be rate year 1 or should it be rate year 3? And we tried to evaluate through different metrics to say what certainty or what confidence that we have for purposes of rate making and the commensurate benefit what ratepayers are paying in, that we can actually complete those projects in that proposed timeline, given that the company can substitute projects as they see fit throughout the process. Then when we take the step back and we talk about the one term, maybe the shadow MYRP or the non-MYRP, those are costs that the company is still even going to perform there. And oversimplifying the process, core components of that, to my understanding, are just general investments that are going to take place as the course of normal work. So while we had our challenges to say, hey, here's a transformer that has a 2-year lead time. Have you ordered it yet? I wasn't able to run that to ground, but the odds are is that the project will likely be completed within the MYRP period should it continue to trend, or the material can be procured.
Well, you started your answer then to actually one of the follow-up questions I did want to ask you, and let me call it, I think you've already described it, so I'll just put a name on it. Let me call it the substitution scenario. So we've got a bucket of projects that are identified in the multi-year rate plan, primarily T&D projects, but as we learned from Ms. Turner's testimony, there's some generation projects in that list as well. And then we've got the bucket of non-MYRP capital projects that we were talking about some with Ms. Bateman yesterday. And so the projects in the, I'll call it the MYRP bucket, those have been through some level of review at this point. The T&D projects had the technical conference starting a year ago, and then there's been rate case discovery by all the parties, and you've got ongoing review of the supplemental information with respect to some projects. The generation projects didn't have the technical conference because that was just for T&D, but it's had a similar level of review. But within the constraints that the statute imposes, the financial constraints of the 4% increase from rate year to rate year, and the earnings band or the earnings cap before earnings sharing starts, those are two financial constraints. Subject to those management under those financial constraints, the company can substitute projects, and it can roll projects in and roll projects out. Is that a scenario I should be concerned about? Is it a scenario you're concerned about? And if so, how do you believe that concern is going to get addressed as we go forward under the MYRP?
Mr. McLaughlin may have more to add on this, but
either one of you.
It is a concern that we're hopeful that the project, that the company can implement their proposed plan and the ratepayers can see the benefits that are laid out by each and every one of the identified projects. The asterisk to that one, if you would, is saying things change. And so the economics that we base this decision on today, my expectation is that the company will reevaluate that when it's time to start the project. And if something changed, that project may go away and something else may take its place. But that will ultimately not be reviewed until the next general rate case. I don't know, Mr. McLaughlin, if you want anything to add.
Right. So I would echo Mr. Metz. It is a concern. We're not saying that we think the company has been disingenuous and they're going to pull a complete bait and switch on what they, but we do not believe that, because there are certainly projects that were identified that clearly need to be done, and they know that, and many of them are reliability related. But it is, I mean, it is a concern, and we will be watching that. Obviously, we will get to audit the projects, the investment in the next general rate case, because at that point in time, if they did substitute projects and they did something else, and that's we will be able to investigate the rate base as a part of the historic year in the next case. Now, monies that were collected, unless they exceed the 50 basis points in the interim period, then, you know, there's not really anything that can be done about that, you know. And I say this with very respectfully, when the public staff proposed our rules for the PBR, we recommended that there be an ability to look at that on an interim basis. The commission, and again, respectfully, you do not believe that the law gives that authority, and so that's the way you wrote the rules, and that's what the law says. That's what we have to live with. But again, I don't want to give the impression that we believe the company's going to pull a big baited switch. I do not believe that.
And gentlemen, by my question, I don't want to give that impression either. But it is one of the comforts of the application we have before us is that the projects that have been included in the MYRP proposal have been vetted to a considerable degree by the public staff. And so I just want to know where I take comfort and how I get comfort if for good and sufficient reasons the company decides to substitute projects, not because they're playing a game, but that means that there will not have been that level of vetting and review. And I'm looking to see, is there any way I can sort of take some comfort out of that process and know that I'm okay before the next general rate case.
Yeah, and before I totally respond to that, let me just say, we are not saying the company shouldn't evaluate if they identify a project that needs to be done and it's more critical than one that's in the MYRP, and they don't have the funds to do both, they should do the more critical project, especially if it relates to reliability. So don't want to give the impression that the public staff doesn't think projects should ever be substituted. But I'll let Mr. Metz take the second part of your question.
It gets challenging, again, focusing sort of on the generation plant side. That if I have a turbine and I'm making investments to the MYRP that were based upon trending data, which the company has done, I believe it's called Optum, at least for some of the fossil plants, or if not all the fossil plants, that they have trending data and they look at it. However, let's hope it doesn't happen, but if the turbine throws a blade, all those plans, it is what it is. And you're going to be in a multi-month, if not year, maybe outage on trying to address other emergent issues. So that's just a function of, respectfully, I think, just natural risk to some degree. The company made a plan based upon the best information that they had at the time, and that was the thorough review that the public staff performed.
Let me ask you this, Mr. I'm sorry.
I was just going to say, just to sort of tie a bow on your question, as to what can be done, I don't know that there's really anything that we can give you that's going to make you feel more comfortable in this initial period. I think when they file their next general rate case, we will see what has happened and we will know then. But I don't know, Mr. Metz has something else, but I'm not sure I can give you exactly what you're looking for.
Well, you've given me one thing, and I'm not looking for absolute certainty. Understand? I just want to understand how this is all going to work. That's all. You have given one thing on page 11 of the stipulation. There's a statement that the stipulating parties agree to discuss the scope and content of proposed reporting on reliability O&M as discussed by witness Metz. That's the topic we've been discussing in the last set of questions and answers. And I want to know if you can flesh that out a little bit more. What do you have in mind there? I know you still have to discuss that with the company. I understand that what that is a commitment between the public staff and the company to sort of sit down and try to put some flesh on the bones, but I'd like to hear a preview maybe, if you're willing to tip your hand, of tell me what you got in mind there.
I'm trying to catch up. So I believe that one is relating to the coal reliability investments and the incremental spend for Duke Energy Progress of approximately. Hold on one second.
Is that limited to the $6 million bucket?
I'm double checking myself. Yes, that to the extent that the programs that the company wanted increased funding for, we want to ensure that those investments are being made. And to the extent that they're not, then we'll have that money ultimately refunded to ratepayers in the next general rate case.
So that provision of the stipulation is specific to the coal plant O&M.
That is my understanding,
Okay.
yes.
All right. Thank you for that clarification. Let me ask you about a couple of other topics. You raised the issue, Mr. Metz, in your direct testimony about the accounting for CIAC in connection with the interconnection costs paid by third parties. And I want to sort of hear you talk about how you think that's going to get resolved through the process established by the stipulation. How do you foresee that getting resolved?
So I believe the intent of when we meet with Duke, we'll be able to discuss to say, okay, how do we want to audit isn't the right word. It's too strong, but there isn't a identified concept which can be tied to specific accounts. And I'm getting a little bit over my skis, and Ms. Boswell, or the accounting panel should probably handle that in more specificity. But the extent would be to say, okay, let's at least identify what's taken place. I was unable to identify exactly the different transitions of different accounts as identified. I believe it's a few footnotes in my testimony say the company identified an issue. This is me paraphrasing. They implemented a change, and then they implemented another change. And that process almost all took place within this general rate case and a little bit before. So how I saw it as an engineer was like, okay, I have costs that may be residing in 3 different accounts. What does that mean at the end of the day to the ratepayer? So that agreement is to sit down with the company to go through and at least identify what exactly took place and have core common understanding of where the costs are residing. More specificity on that request, I would defer to accounting panel.
I just made a note. Thank you. Let me move back for a minute, and I want to ask you a dumb layman's question. So I read your testimony about the coal plant unit availability, and your concern about declining trends of unit availability. And again, I'm a layman, and I'm reading this, and I'm seeing we got 2 plants, and how many units have we got? 5 units, 6 units in those 2 plants, Mayo and Roxborough. And you're telling me in your testimony that I should be concerned because those units are increasingly just not available for service because of lack of investment, because of staffing, because of age, because of all sorts of combinations of factors. And so I'm again, the dumb layman in me says, well, why am I continuing to operate 6 of them at a very low level of service when I could probably operate 2 or 3 at a much higher level of service? Is that a dumb question?
It's not a dumb question, but trying to take a step back, I believe respectfully, the core element that you may be disconnecting from.
That's what I'm looking for.
At the end of the day is we still need that capacity of all 5 units.
Okay.
Yes, from an energy standpoint, you're probably spot on to say we can operate these units more. Hypothetically, let's retire Mayo, and we'll just run Roxborough more. Hypothetically, I need that approximate 700 megawatts out of Mayo, and then you'd also have to evaluate the potential transmission impacts, and then you have to stagger outages. You could bring down, say, Roxborough Unit 1 and 2 and bring Mayo online, which creates grid support in that part of the system.
It's a capacity need, not an energy need.
Yes, sir.
I got it. You answered the question. Thank you. Mr. Metz, one last one for you. On page 38 of your testimony, you discussed the Duke's proposed allocation of coal, 60% to DEC, coal costs 60% to DEC and 40% to DEP. And you had some questions about that. Witness Turner has stated in her testimony that the cost sharing is based upon each company's identified needs, not based on some just high level number of units per company. Are you satisfied with the answer? Is there anything else we need to ask about? Is there anything else you need to say about that issue?
No, I believe Ms. Turner's testimony clarified it.
We're good to go.
Yes, sir.
Okay.
All right, I'm going to interrupt you. We're going to take our afternoon break. We will be back on the record at 3:30. Let's go off the record, please.
I'm sorry. What?
Signal when you're ready. Okay, we'll be back on the record. All right, Commissioner Clodfelter, you may continue.
As I said yesterday, it's dangerous to take breaks. Mr. Metz, back up. Give me the name again, because I didn't write it down, of this gas project you were talking, just, what's the name of it?
Advanced gas path inspection,
Advanced gas?
advanced gas, and I forget the rest of the acronym. I think it's advanced gas path.
Path inspection. The fact that you call that one out suggests to me it might be of some importance to you. So I wanted to ask a couple of follow-up questions about it, because when you give it a name like that, it says to me, you're looking at it. Is that a project that you expect to be reviewing in some of the supplemental information that's been given to you that you hadn't been able to review as at the time of your last testimony?
No,
All right.
no.
Do you know when that project is expected to come into service?
I believe that project is expected to come in service. There's different parts of it. I believe it's based upon the MYRP schedule, in my understanding, that the unit is likely down and under repairs right now than is being implemented as we speak.
So it might come into service sometime between now and fall.
Most likely, the outage for turbine is much less than fall. It'll probably most likely in service within a month, or within the month, or within the 6 weeks, depending on what items are found, of course, during the nominal inspection.
Okay. All right, thank you. Mr. McLaughlin, were you here that yesterday afternoon when Ms. Bateman was testifying?
Yes.
Thought you were, but I couldn't remember for sure. And so I asked Ms. Bateman the sort of the open-ended question, what, if any, are the changes in risk profile for the ratepayer from a multi-year rate plan as compared to a traditional historical year rate or rate making? What do you say about that question?
Well, it might not surprise you that maybe the public staff's view is not exactly like Ms. Bateman's. In fact, I listened to her testimony, and I say this somewhat in jest. I started wondering why the company wanted the MYRP. There seemed to be so many risks, but no, I know why they wanted it. But so one of the risks to customers that we already discussed with Ms. Kress, the significant increased workload, and it somewhat hinders the public staff's ability to be as thorough as we would like to be. I think it was Mr. Jirac, but I could be wrong, made a comment that in the company's rebuttal, they appreciated the public staff's level review. I didn't quite take the rebuttal that it was an appreciation, but anyway, I'll give him the benefit of the doubt on that. But yeah, other risks to customers, I mean, just quite frankly, the rates go into effect a lot faster. So we've got rate increases going into effect before projects are completed and in service. I mean, that's different so customers are paying for things before they're seeing the benefits in some cases with the MYRP. Now, Ms. Bateman talked a lot about regulatory lag, and we all acknowledge that is an issue. And I know the utility generally sees regulatory lag as a negative, but to a consumer advocate, regulatory lag is not always a bad thing because it puts some spending discipline on the utility in between rate cases. So that now is at least lessened. I won't say there's no spending discipline on the utility, but in my opinion, it's lessened. We talked about a little bit before about projects that are proposed and that are being paid for may or may not get built, and yet the customer is still paying for it. I think this was touched on earlier today, but while it's true that in rate years 2 and 3 of the MYRP, the increase is limited to a maximum of 4%. When we assume, and I think most of us all assume, that there's going to be another multi-year rate case filed that would take effect 3 years from when this one takes effect. I mean, I assume that's the plan, and because of this significant spend from the shadow MYRP projects that won't be limited to the 4%, when we go from rate year 3 to the base year or rate year 1 of the next rate case, the increase could be much, much more than 4%. So we're not limited to a 4% cap from here on out. I've heard comments that, well, one of the benefits to customers is that we will reduce the number of rate cases, and hence there'll be less rate case expense incurred. Well, maybe, I don't know. I mean, if you look back over history, I think since 2012, I think is this the 4th DEP rate case in the last 10 years. So we're averaging one about every 2, maybe 2.5 years. If we get on a cycle with the MYRP, I mean, in order to get it in place so that the next one takes effect as soon as rate year 3 ends on this one, we're going to be looking at a filing in about 2 years. I don't know that I see, unless the utility is planning to start filing them every single year, which we've never done that, or at least not since I've worked for the public staff. I guess I don't see that. I know the rate case expense in this case is much, much higher, maybe double what it was in the 2019 case. Ms. Boswell can address that, or Ms. Zong, their panel can address that better than I can. Few other issues. So let's see. So those are some of the, the risk I see. I guess one other one. So there is an earnings sharing mechanism. So if DEP is earning more than 50 basis points over what's allowed, then they would have to give that portion back. I guess I don't see that as a very likely event, at least not in this initial case. I think with the additional projects outside the MYRP, the significant spend there, I think it is highly unlikely that we'll ever approach an over-earning situation. And that's just my opinion. As for the ratepayer benefits that we see coming out of this, I hate to put this all in your lap, Commissioner Clodfelter and fellow commissioners, but I think it largely depends on you all, what the benefits are. The public staff obviously believes that there is a reduced risk to the utility from implementing this. So that will depend on you, whether you feel that that's the case, and make that type of adjustment whenever you approve the ROE. That would be a direct benefit to customers. Again, how much you decide to hold Duke accountable for the commitments that they've made and the plan that they've put forth. We know that we have to spend significant money to achieve the carbon plan, and the mandate within 951 is to maintain or enhance reliability. So a lot of the money has to go to that. And so what type of guardrails do you ultimately place on that to ensure that's where the money is going, so that customers do see the benefit at the lowest cost? Going back to the possibility of the earnings sharing mechanism, just ensuring that the earnings reports are reported accurately. I know Ms. Jiggets yesterday, and I don't mean to just call her out, but she raised some doubt as to the ES1 reports and to how valuable they really are in measuring actual earnings. And I think Commissioner Clodfelter, you shared the concern, well, you have to have the commission has to have something to measure this, and something that you can rely on. So, that's, if we can't rely on those reports, then the ratepayers wouldn't realize that benefit. So we need to have a report that we can rely on. And then, I guess the PIMS, of course, there have been several settlements around PIMS, some that the public staff is a part of, some that we're not. And the commission, you all may decide that you want to either modify those or add to or subtract from, whatever. But ultimately, whatever you approve, we need to make sure that those are tracked and reported accurately, because we believe there are customer benefits within those PIMS if they're carried out, and if where the company can either be rewarded or penalized if they don't follow through, or not follow through, but don't meet some of the goals. That the reporting of that would go a long way as to whether customers see those benefits or not. So I think Mr. Metz may want to add to it. Those are just some of the things that I see.
I have a hunch you might get questions from some others to follow up, but so I'm going to go away from this, but I will ask one follow-up, and then I suspect you will get some other questions. But so one of the risks that you've identified, and we were talking about it earlier, maybe when in what I called, it was my name for it, the substitution scenario, is that either a project for which revenue is put into the rates now, the project's either not built, or a project is substituted for it that is later determined not to have been a prudent substitution. Well, I don't want to put words in her mouth, but I think it's be an accurate statement to say that Ms. Bateman would say, well, that's not going to happen. Number one, she would say, but number two, she would say, even if it does happen, the risk is limited to 50 basis points. Would you agree with that statement? That risk, that the risk that there's more revenue put into the multi-year rate plan, and then projects don't materialize for which revenue is put into the plan, or imprudent projects are put in the substitution, that risk is limited to 50 basis points. Would you agree with that?
Not totally.
All right. Well,
no, because
tell me why that's wrong.
Well, and maybe if I'm not understanding your question, please correct me. But again, it goes back to the 50 basis points is whether we're measuring their over earning to the point that they need to refund money back to customers or not. And as I said, with the significant, the shadow projects, the shadow MYRP spend, there's so much money there that it's going to also go into the earnings calculation. That they're spending that on top of the MYRP, it's unlikely that we're ever going to reach an over earnings point, at least in this case.
All right. Well, we keep coming back to this point, and I've asked it to you before, and so with apologies to you, and I promise I won't do it but once. I'm going to ask the question a second time. So, is there anything we can do now to sort of manage that risk going forward? What should we do? Is that something that needs to be considered as part of the annual review? And if so, how do we consider it as part of the annual review? What do we do? I'm looking for guidance genuinely. And if we don't know the answer right now, we don't know the answer right now. That's fair.
Well, it could be part of the annual review in terms of monitoring what is spent and what, and spent on what, and how that compares to what the projects are that are included in the MYRP. In this case, I'm thinking back to the rulemaking proceeding, and I'm not sure
Right.
what we could do about it, but will at least be informed of it.
All right. As I say, others may have questions for you for that. I'm going to go jerk you all the way to something else. Now, you know what it is.
I'm afraid I do.
Yeah, okay. And I know the public staff's witness is David Williamson on cost of service, but you were around here in 2012, if my memory is right, and I wasn't. You were. So I got to ask you because I wasn't here.
All right.
All right. So what were the articulated reasons that the company advanced in 2011 or 2012? I forget when the rate case was filed for converting from its position of summer, winter peak and average to coincident peak allocation for production cost demand portion of production cost.
Right. So remember that in 2012 was right after the merger between Progress Energy and Duke Energy. I believe it was consummated earlier in 2012. And Duke Energy, Duke Powered, you and I both remember when it was Duke Power, Duke Energy Carolinas had for as long as I had worked for the public staff, and maybe for as long as there have been rate cases, had used the summer coincident peak allocator for allocating production plant. I'm not aware that they had ever had an average demand or energy allocator for production plant. Progress, which at the time was CP&L, I believe it was first approved for them in a rate case in 1982. I think that was the first time, and it had been approved in 3 subsequent rate cases after that. Of course, then we had this 25-year period when they weren't in for a rate case. And my understanding is that now that we've got 2 utilities owned by the same parent corporation, they did not want to have 2 different cost of service methodologies. And so they chose to go with the Duke Energy Carolinas methodology for Duke Energy Progress in the 2012 rate case.
Did the public staff take a position on that change at the time?
Oh, yes.
And that position was?
Well, I was the cost of service witness in that case, and I think the CUCA attorney at the time, who was Mr. Bob Page, crossed me for about 3 hours on that. And so the public staff advocated for the peak and average methodology, and the company wanted the single coincident peak, and so did some of the other interveners. And ultimately the commission, I think, I can't speak for why the commission ruled the way they did, but decided to go with the single coincident peak methodology.
It's been the public staff's position consistently since that time to the present that an allocation methodology that incorporates an energy component, i.e. the average component of peak and average or average and excess, whatever name you want to use. That's been the consistent position of the public staff since then, is that that's the preferable methodology. Am I correct?
Yes, we had not ever advocated for the average and excess methodology, but the average component is exactly the same in that methodology as it is in the peak and average that the public staff has advocated for prior to that. And that was very important to us. And so when we went through the stakeholder process with all of the various parties on cost of service methodology, that was something that particularly when it was time, when it was proposed that maybe we could reach a settlement, that the public staff was very firm that there had to be some methodology with an average component.
Okay. All right. I think I'm about done here. Let me stay with the cost of service stakeholder working group. And I know Ms. Bateman testified about that yesterday. I think I'm not sure whether Ms. Hager touched on it, but I know Ms. Bateman did talk about that. And you heard her testimony, I think you said. And she explained to me that in the course of that working group, the stakeholder working group, that various scenarios using different allocators for the demand component of production costs were run. It's my understanding that that information is not in part of the available materials from the comprehensive rate design task force, and that they may not be in the record. Let me say to you, Mr. McLaughlin, and also to council, that is the kind of information that I was asking for from Ms. Hager. And so if that information is available and you can direct me to it in the record somewhere, then I don't need a late filed exhibit. If it's not in the record and not available, then that may be the information that is I was trying to get at with Ms. Hager.
Right. The report that came out of the stakeholder process was filed with the commission on January 5th, 2022. It was filed in the two previous rate case dockets, E7 sub 1214
and E2 1219.
And E2 sub 1219, yes.
Well, were the working papers, and that's what I'm really focused on. The scenarios that were run that Ms. Bateman referred to yesterday, were those part of the filing?
Yes.
They are part of the filing.
Well, when you say working papers, I mean, it's not like the active spreadsheets, but there are descriptions of each one of the methodologies that were considered, and there are how many exhibits? 22 exhibits attached, each one referencing different parts of each methodology and what the different components work out to be, whether there's the rate of return, return index, allocation factors for each individual methodology. And then there's a consolidated sheet that lines them up so you can see single CP, 4CP, 12CP, average and excess, summer, winter, peak and average, and you can look across and see how they compare with each other. I don't know if you're asking for more than that.
I am. I know what you're referring to. That's the narrative explanation of the elements of the different methodologies. I'm looking for how they would actually shake down into dollars allocated to each rate class. If you applied single CP, 2CP, 4CP, summer, winter, peak and average, average and excess, 12CP, what do they look like when you then allocate them to DEP's rate classes?
Okay, so yes, that is not included in the report. That was the foundation for the results that are in the report. That would be something that the company would need to provide, and I'm sure they have it.
All right, well, that's enough, and that's fine for now. Based on what Ms. Bateman told me, as you've now explained and clarified it, I think maybe the company has an understanding of exactly what I was
So
looking
you're
for.
looking for the backup to the report?
Yes, sir.
Okay.
Yes, sir. That's all I have,
Okay.
gentlemen. Thank you.
Sorry, Commissioner Clodfelter.
Yes.
Did you have a question on Hot Springs that wasn't answered from previously? It was something about cost allocation. I believe you asked early in the hearing.
Not about Hot Springs. No.
Okay, sorry.
I think someone else may have, I think Chair Mitchell may have asked a question about Hot Springs.
If there's questions about Hot Springs.
Do you have information, Mr. Metz, that you want to convey to the commission about Hot Springs?
Yes.
Would you please convey that information?
There's a questions about Hot Springs and in relation to the settlement on the production cost change, was originally booked the distribution and production plant based upon the settlement position. It was approximately $800,000 decrease to NC retail, not at the revenue requirement, but overall. Apologies if I've misremembered the commission's questions.
So can you say that again, Mr. Metz?
So Hot Springs Microgrid, the company's as filed position, it was simplifying, it was booked to two accounts. One was distribution, one was production. For purposes of NC retail,
any cost booked to distribution is 100% assigned to NC Retail. Approximately 62% of the costs of the project or production base is 62% of the cost to be assigned to NC Retail. Based upon Mr. Thomas's recommendation, and ultimately what was settled upon, cost moved from some of the costs moved from distribution into production. That net sum ultimate reduction of approximately $100,000 at NC Retail.
Commissioner Clodfelter, one of the advantages of being ancient is that you're actually around.
Speak
at a
for
time-
yourself.
Well, I am speaking for myself. That you're actually around at the time that some of these controversies about the summer, winter peak and average, et cetera, were playing out. And I do recall I believe it was Mr. McLaughlin indicating that Mr. Manus was very passionate about the public staff's views on these things. But if you want to get a little history lesson on it, in that case, the 2012 case, the public staff and the company settled almost all the issues but two.
Are you in?
No. I'm just talking as a lawyer here. There's
Would you like to point me to something in the record? I think that's more appropriate.
Yes. In the pleadings, there will be a joint proposed order of the company and the public staff. And it will have, or maybe it's separately filed, opposing views as to the two unsettled issues, one of which was the peak and average versus single CP. And I think you'll find a fair amount of history there.
Thank you, sir.
I need to correct Mr. Mehta on one thing.
Maybe it was Mr. McLaughlin who was passionate.
Mr. Page asserted that I was passionate about cost of service. I've never forgotten this. I forget a lot, but somehow I remember this from 11 years ago. And I told him I was passionate about many things, but I don't think I would describe myself as being passionate about cost of service. And you can check the transcript on that, but I'm sure you don't want to.
I was actually looking for the transcripts. So I was trying to figure out who was passionate about what. But,
This hearing is going long enough, and I don't think the chair wants to extend it by replaying the history of a prior rate case.
No, you don't.
All right, Commissioner Duff.
So I would not consider myself ancient, but I do remember that testimony. So let's talk about your discussion with Commissioner Clodfelter about the risk to customers. You stated you were talking about how House Bill 951, requires enhanced reliability. And so you mentioned that it would, that public staff would like to establish guardrails, so the money is going towards meeting that goal. Do you have recommendations regarding those guardrails?
I want Mr. Metz.
I can start. We have the reporting requirements, so I mean that is a reactive measure. So I think we're limited to some degree to the extent that if we were to notice something, we would have to notify the commission. Then what would the commission want to do in reaction to what's being observed, and how much time would take? So the potential guardrail would just be clear insight into what's being reported, and either by direction of the commission or what the expectation is what will be done either on an annual or quarterly basis with that report. I'm not volunteering Mr. McLaughlin for more work, but that could be potentially a guardrail provision, especially for the first of a kind electric MYRP.
Okay, and no other guardrails that either of you would suggest at this time?
Not at this time. I mean, there are lots of things that we would probably like to do, but not sure are allowed by the law. So.
Okay, Thank you. Then you mentioned that the public staff thinks it would be necessary to have more accurate quarterly surveillance reports. And I'm not sure you two were in the room when a DEP witness said that more accurate surveillance reports could be done yearly. What is public staff's response to that?
Okay, just to be clear, I'm not asserting that the reports aren't accurate. I was saying that whatever we get, we need to be sure that that the commission and other parties have information that you can rely upon. I think the company's witness, Ms. Jiggets, had indicated that maybe because of the nature of how the reports are put together, that she didn't think it gave, I guess, a complete picture of the earnings. But as far as what types of adjustments that would need to be made, I would defer that to our accounting panel. I'm getting a little out of my league.
Okay, thank you. And then you talked about the risk of a customer paying for a project that may or may not be placed into service. And I'd like to talk a little bit about that, as well as these substitutions of projects. And I just want a better understanding of how you see it working in the context of the next rate case. And so I'm going to throw out a hypothetical. So let's say we have project B, and it's a rate year 2 project. It's not ultimately built, and you go into the next rate case. It's not built into year 2, year 3. It's built in, let's say, year 5. So it's been built, but not within the rate period. How is that going to be handled in the next rate case?
I was thinking about this earlier today. So if it is a part of the revenue requirement in this case, the company is going to rates will be based on that project. That project B, is that the way you refer to it?
Sure.
So customers will be paying for that starting in rate year 2. And so if the project doesn't get built, I guess there's 3 things that could happen. Another capital project could get substituted for it, in which case that one would get built and it would go into rate base. Or the money could be used for something else. It could go to operating expenses. It could go, maybe there's a project that does get built that cost more than was estimated, and it goes to pay for that project. Or I guess the third option would be it would go to the company's earnings and would show up that way. They would collect the money, not spend it, and it would increase their earnings. Now, I mean, we're talking about hundreds of projects and billions of dollars, and we're trying to single out the effect of one project. And I know you know that, but
Right. This is just a hypothetical, just trying to see how the auditing process might work within the next rate case. And so let me interrupt you on that. So let's say that the money goes to something else, and then but they're in for this next rate case, and the project B shows up there. So the ratepayers, so I'm trying to figure out what happens to project B in that next rate case if it hasn't been built in the 3 years, you know, if we agree to do this multi-year rate plan. If it's not in this multi-year rate plan and is pushed to, let's say, the next multi-year rate plan, how is that going to work? One, if the money's just going to something else, and then I want to talk about the substitution project.
Well, I suppose it would show up in the next MYRP list of projects for the next case. As to what happened to the money, the public staff will be auditing the projects that were in this MYRP, or maybe not in this MYRP, but are now closed to plant when we get to the next rate case. And we're looking at that historic year, that base year, and I don't know that we'll be able to do 100% audit because there's so many of them, probably not, but we will look at those for reasonableness and prudence.
So I don't know if your question's gone this past. So using this project B, and let's call it $10 million, and we don't build it in this MYRP and decided to build the next MYRP is going to see the full $10 million. That's my understanding. It's not going to see 10 million minus whatever got depreciated as a proxy project over this MYRP period.
Okay, and let's talk about the substitute project for Project B, $10 million, Project B. There's a substitute project because of reliability issues. Do they tell you that they're substituting Project B with this Project C? Or how is the company and how's the commission going to know that there was a substituted project?
Well, as to when we would know, I'm not sure. I mean, I think that could be part of the annual review, reconcile that. I mean, we will certainly by the next general rate, the next filing of a general rate case, we'll want a reconciliation. I'm sure that'll, Mr. Jarrett can go ahead and start getting ready. There'll be a DR that'll want a reconciliation between what was proposed in this case and what has been placed in service. So he can get started on that tonight.
Okay. And that answers my question about the reconciliation piece.
Commissioner Duffley, if I may, I mean, I think that may be, I mean, just thinking here is just, that might be part of the guardrails of saying what enhancements could we have on the quarterly reporting? Again, perhaps that a guardrail that may go a long way to say, all right, in a quarter report shows what you spent by project, but show us what you plan on spending over the next 3 months on these particular projects. So you have that look back to what was spent, and then you have your alignment for the next 3 months, so you can sort of continue to track general projects. And to the extent that a project gets substituted or delayed from the original filing, that potentially could be annotated, and therefore there's transparency throughout the entire process.
Okay, Mr. Metz, if we could turn to the issue of this gray period. Did you hear witness Bateman talk about the gray period? And it was what I heard was, and we all know what gray period means based on your conversation with Commissioner Clodfelter. Okay, that the DEP's interpretation of the statute is those projects would move into the multi-year rate year one. And then she said, ask public staff to make sure they agree with that. And I'd like to hear public staff's position.
So we had a lot of internal conversations on this element, and some of it or legal based and interpretation of the statute and getting way over my skis. Is a statute take priority over top of a rule? I'm waiting for my counsel to throw something at me. This is the engineer trying to explain it. I think one of the binding factors is that when rates go into effect. And when rates go into effect, you have your sort of 3-year forward, your 36 months going forward. So nothing really could be done until rates go into effect. But the rule defined the periods of 12 months per rate year and 36 months per rate year. So we were in conflict that the true definition of 12 months is 12 months. It's not 18 months. It's not 17 months. So it got into a discussion of what was perhaps the intent of the law and the statute, and it was ultimately our position that the gray period, if you would be allowable, but that is in partial conflict to the rule of how it is could be interpreted.
Okay, thank you for that. I don't have anything further.
It did. All right, let's see. Commissioner McKissick?
And I just wanted to follow up a little bit more on some of the questions Commissioner Duffy was asking you about these substitutions. Now, if this project that's proposed, say it's project B, it gets kicked back into the next a multi-year rate plan cycle, there is another substitution that pops up. How are the costs for that substitute project that we've not contemplated, that might not have even been a part of the initial list? How do we address those costs?
So if I'm understanding, so we have in the current MYRP, I had this project B got bumped out, a new project came in, took its place.
A completely new project that it was on no one's radar screen at all.
So a new project came in, the project would be closed to plant, and normal depreciation would start, and believe that would be offset to the revenue requirement being collected through the MYRP. And so when you start the next general rate case, or the next MYRP, is essentially in non-accounting term, sort of a true up between the two. What was recovered versus what was the actual spend. To the extent that the substitute project cost more, then we'll pay up to that incremental part going forward.
Okay, got it. But I guess the thing that's giving me the greatest concern is that I'm full reasonably certain that there will be a lot of substitutions that will take place. And perhaps it'll be among projects that are currently contemplated, but it could be among things that, emerge, at some point in the future. And it would be good to know through this quarterly reporting or somehow when these types of substitutions are occurring, so there can be a level of scrutiny provided early on before it gets too far along. Do you have ideas about how we could make certain that occurs?
So Mr. Malahor may have something to add, but I believe that some of the guardrails that Commissioner Duffley was potentially asking us about, and I don't know if we have those fully vetted at this point in time. So I think I was potentially proposing a solution is, I know the consumer advocate would like to see, is saying you had your list, show us on these quarter reports of these changes, show us what your next 3 months projections been, and at any point in time, if a project is delayed, it can just show that the project got delayed or it got flagged, or then you can track through the quarterly report cost deviations. I mean, that could be something perhaps for a commission order that we work with the utility to find a better resolution, perhaps for more transparency and scrutiny and reporting metrics. Give me more time. I'm sure I can probably come up with some more reporting metrics along with other engineers and public staff. But so I sit here today, that's about one I can think of, Mr. Long.
Yeah, that was my thoughts when I was having a conversation with Commissioner Duffley, and I don't really have anything beyond that at this point, but that I'm sure we, would be happy to work with the company to try to come up with something.
I mean, is it possible to give that some thought in terms of what measures could be implemented in those set of circumstances, or other circumstances that we might not have articulated that you might envision, and maybe put it in a late file exhibit?
We'll do the best we can.
Well, I understand. I mean, I understand it's something you haven't perhaps given great thought to, as well as, I mean, the level of auditing you guys are going to have to do with all these projects in the future.
We have given it a lot of thought. We just haven't come up with a lot of solutions, but we will see what we can do.
Excellent. And to be completely candid, I appreciate the testimony you have provided today, and I think between Commissioner Clodfelter and Duffley. So many of the questions I had in the back of my mind have been asked and answered. And I know it must be challenging when you're dealing almost with what I would call 3 or 4 rate cases in one with limited time and resources. And I appreciate the thoroughness and vigorousness of the reviews that you have conducted and the testimony that you have put into the record.
Thank you. And I think just to the question you had about the substitute projects, Commissioner McKissick, I think when the rate case was filed, Mr. Metz will correct me, but I think there were over 1,000 projects in the MYRP in this case. And that was ultimately modified to 800 and something.
70-ish.
But, and I think the company staff, as we were talking with them, they refer to it as a parking lot. They've got this entire parking lot of projects that they can draw from and substitute. And so, you know, it was a challenge to try to review the 800 or so projects that were in the case. And there was very little ability to go into the parking lot and start reviewing those because they weren't actually in this case at that point. So,
and you did resolve some issues related to the cost of the projects.
Yes. Yes,
sir. Correct my recollections as to what was ultimately resolved in that regard. I think it was in the stipulation.
Yes, Commissioner McKissick, we resolved the sort of the cost estimates, the stale estimates, as well as other factors, sort of the risk contingency.
And are you comfortable with the way that got resolved in the stipulation, or do you think more needs to be done in connection with what was stipulated to at this time?
I believe for the first ever electric MYRP, the stipulation is fair, and I agree with it. However, I would just add that for future rate cases, we can continue to apply lessons learned, work with the company, and mitigate some of the challenges that we had and that we found in this case and prevent reoccurrences, which the company did work with those within the Duke Energy Progress case.
Well, it's going to be a steep learning curve for everyone. I hope and trust you guys are around longer than we are.
Commissioner Kimmerer. Just one question, just to try to sum up what your testimony is and what we've learned about the risk to ratepayers about these capital projects that may not be constructed during the MYRP period. And so I'm just going to walk through what I heard about the risk. And so if a capital project, MYRP capital project, is not constructed during that MYRP period, then potentially another non-MYRP project could be substituted for that project. And then there's also, secondly, there's a protection for ratepayers about potentially refund through the earnings mechanism. But I think I heard also that at least for this first MYRP application, there's not really any concern about over-earning on behalf of the company in this particular MYRP. And then the one item that I did not hear testimony about, but was in Mr. Metz's testimony on page 49, talked about if a capital project is delayed and is not constructed during the MYRP period, that there could be potentially increased labor or materials cost if it's delayed. But if another project is accelerated and substituted, then it would have the benefit of not having the delayed, potentially increased cost for labor or materials. So that's kind of the summary of what I heard about risk. So it seems like risk is mitigated with these different types of measures. Am I misunderstanding the testimony, or is there some other risk that we haven't talked about?
I'll address the part that you had about the earnings sharing. I'll let Mr. Metz address the other side. I'm not speaking for the company. I don't know maybe they have great concern about over-earning and having to refund money. I'm saying that from the public staff's point of view, given the amount of additional spend not related to the MYRP projects, we think the risk of having to refund any money is the risk that they will is minimal. So I can't speak for them. They may have a totally different viewpoint.
In regards to in regards to the last time you identified, that would be true.
Okay. Thank you. Thank you for the clarification.
Mr. McLawhorn, we're curious about the transmission cost allocation, and recognize that this issue has been settled between the company and the public staff, but the settlement, as we understand it, ultimately adopted your recommendation for the revenue adjustment. That's not the technical term, but that's what I'm going to use. Can you explain to me how or why your proposed adjustment that's been memorialized in the settlement or accepted by the settlement is the appropriate adjustment?
I'll start on this, and then I'll let Mr. Metz take over. So, this goes back to the carbon plan hearing. You and I had a lot of conversation about this, that the public staff had raised this concern about the cost being imposed on the capital cost being imposed on DEP customers for the benefit of the entire state. And so we have been, trying to determine what would be an appropriate mitigation strategy for that. And I think initially we focused on looking at some way to allocate plant costs that were billed in DEP, a portion of those to DEC. And the more, we thought about that and the more discussions we had, that seemed like that was going to have a lot of difficulties accomplishing that. It just was. And so we started thinking about what else could we do. And so we decided that what we're really talking about here is clean energy that's being produced in DEP and is being transferred to DEC for their customers' benefits. So we're really talking about use of the DEP transmission system by DEC customers. And because of the way the JDA, the Joint Dispatch Agreement, exists, there are currently no, the two utilities customers don't pay transmission costs to each other for the use of their facility. So we thought, well, what if there was a way to impose is not a good word, to have some type of charge that would be applied to the transfer of energy, non-firm energy back and forth, which has to use the transmission system. And so we thought about that, and we thought, well, what charge would we use? And so we considered, well, maybe, we need something that has been vetted and is cost-based. Well, we could go to the FERC tariff and we could look at the non-firm transmission charge, and we could use that as a proxy, because that would be something that would be very transparent. Everybody could go to the OAP, they could find it. There's no question where it came from. So then our concern was, well, because we're using the OAT, could this somehow run afoul of FERC? Would this cause some problem because FERC had approved the JDA and the OAT is really a FERC tariff? Would they would this cause a problem? So we had several meetings. We proposed this to Duke. We had talked with them about that, and we had meetings with their FERC attorneys, and we were assured that as long as it didn't change the way the cost within the OAT were allocated, and it didn't go outside NC retail, that this just stayed within the North Carolina retail jurisdiction, that FERC wouldn't care and there would be no problem with it. It would be a matter of, is that something that we wanted to do, and would the commission want to do that? And so I guess what I'm saying is we're not saying this is the perfect solution, but we didn't really get any suggestions from anybody else, and this is what we were able to come up with. And Duke said, we don't think there's a problem with it. We don't know of any problem with doing this. And so that's where we are.
So, I mean, Mr. McLaughlin predates me by all means, but how the JDA was originally envisioned, that some years it's all about least cost dispatch for the Carolinas. Makes perfect sense. Some years Duke Energy Carolinas may help Duke Energy Progress. Some years Duke Energy Progress may help Duke Energy Carolinas, and you sort of have this ebb and flow. Over time, it looks to be on net flowing one direction, and that's what's identified on table 3 of my testimony. And it's saying, okay, at the end of the day, what's really taking place? And this isn't, this wasn't a nefarious act. This is just realities, how the system's changed, and with the structure that exists is that Duke Energy Progress ratepayers are paying in base rates capital and ongoing O&M of the transmission system, with energy flowing over to Duke Energy Carolinas, and Duke Energy Carolinas aren't paying a commensurate cost for that transmission and ongoing O&M of the transmission system. So while that observation has been noted over time, really the carbon plan really heightened the amount of energy transfers that are taking place. And I believe this was in Mr. Thomas's and myself's testimony in our comments, that it continues to increase and increase and increase, exacerbating the issue that we're already seeing. So this position or this proposal ultimately is just saying DEP ratepayers should receive a commensurate benefit for the cost of their system, and we're using, based upon the JDA as non-firm, a very transparent and a repeatable process, and using the non-firm OAT tariff. And it's based upon our understanding is that we're not impacting wholesale rates, that this is a function of North Carolina retail rate making.
All right, thank you both for that explanation. All right, Mr. Metz, another settled item is the 5% downward adjustment to the multi-year rate plan projects. My understanding of the settlement is that adjustment has been accepted by the company.
The 5% project efficiency adjustment for purposes of settlement was not accepted and not reflected. The 50% contingency adjustment was ultimately agreed upon between us and Duke, which was approximately subject check around 200 million NC retail.
Okay. So you've, all right. Well, that's our mistake. Let's see. Commissioner Clodfelter covered much of the material we had for you.
And sorry to add on to that, I mean, that's where we also consider that's a benefit that would also help, from public staff's view, incentivize Duke to keep cost and mitigate their risk and bring the projects in on budget.
You all have discussed sort of at length with a number of the commissioners the sort of scenarios and hypotheticals about what could happen in the coming years while this plan is in effect, assuming it were to be approved. The commission adopted some reporting requirements in its rule R117B. And my question for you all is it recognizing that the commission might not have adopted every single recommendation of the public staff and those rules, are there specific provisions or is there additional information that the commission should consider for purposes of those reporting requirements? And you've mentioned some, you've talked with commissioners today about some, but to the extent that there are specific, additional measures that this commission should consider for the reporting obligations under the rule, given what you all have learned as going through this process so far, please make those known in your post-hearing filings. All right, Mr. McLaughlin, I'm gonna ask you, Commissioner Clodfelter gave you a few softballs, and, I appreciate your testimony and the experience and perspective that you share with us when you're sitting in that seat, and we don't have you up here very often. Anything else that we need to know? Anywhere else we need to be, any specific issues or other issues other than ones you've touched on today as we proceed through the rest of this proceeding to final order?
Well, I guess I'll sound somewhat like a broken record, but I don't think this is really news to the commission or anybody in this room, but costs are going up, and we talked about this during the carbon plan hearing, and they're going up significantly. They impact people. We heard the witness for Parkdale Mills earlier today and the pressures that industry in the state is facing. I think that's part of the reason that we believe that this transmission adjustment is important to try to help mitigate some of the costs on DEP customers who are already paying substantially higher rates. I know that the commission is aware of, you went to all the public hearings, you heard the public testimony and the pressures that are on customers from increasing cost. The other day I was reading a customer statement that was sent in to the commission from a lady who said that her sole source of income was Social Security, and it was, I think she got something like less than $1,000 a month. And I was thinking about that, and then I got a notification last week from Duke Energy Progress that my balance bill payment is going up, and it's going up $25 a month. And less than a year ago, it went up $20 a month. So my balance bill payment has gone up $45 in less than a year. And that doesn't take into account anything from this rate case. And I thought, how would that lady, that's getting less than $1,000 a month. I can pay the $25 increase. That it's not like I can't afford it, but that would be significant to her. And it's not because I'm a huge energy user. I have a lot of gas consumption at my house, and I think the last report I got, my average electricity use is only 884 kilowatt hours a month. That's well below the 1,000 kilowatt hours that we use. And people that lower income people, as we've heard testimony, their houses aren't the best insulated, so her usage could be considerably higher than mine. And I'm sure a lot of this increase is based on increasing fuel costs. But yeah, I just hope and I know you do, that the commission will keep that in mind when you're reviewing this application and considering the risk that customers are facing from this. I hope that that's something that everybody will keep in mind, and we'll try to keep costs as low as we can. So I guess I'll leave it at that.
All right. Thank you very much. And thank you, Mr. Metz, for your testimony and your participation in this case. Go ahead.
So I think Chair Mitchell actually went where I was going to go with you, Mr. McGraw-Horn, but I think I'll go for just a slightly different, but same idea. So I think you and Mr. Metz both have been in the room for most of all the preceding testimony, and I know you confessed or revealed that you were taking notes. And I just wanted to know if you heard any testimony or anything came across that you thought didn't come across quite the way you would like it to, or seem to lead us in a direction that you wouldn't have us go. Is there anything like that that you or Mr. Metz? Mr. Metz already jumped in on one item. So did you have anything else like that that you wanted to bring to our attention?
Not that I haven't already covered, I don't think so, but I appreciate the opportunity. Mr. Metz takes better notes than I do.
I concur.
All right, thank you.
All right, questions on commissioners' questions. We will start, let's see. You all have any over here?
Can we, I think I asked that.
Chairman, should I request that we go last on question on commissioner questions?
Well, we'll let the public staff go.
I'm
first.
sorry, before the public staff.
All right, Ms. Kress, you may proceed.
Thank you, Chair Mitchell. Gentlemen, if I could have you turn to SIGFR potential exhibit number 88, which is the cost of service study per stipulation in the last two rate cases.
Put your microphone down just a little bit. Thank you. Say 88.
Yes, Mr. McGawhorn, 88. And at this time, Chair Mitchell, I'll ask that this be marked SIGFR 2 cross-examination, Metz and McLawhorn, exhibit number 1.
Let's see. Ms. Kress, remind me of the proposed number, the potential number.
88.
Okay. All right. We'll identify it as SIGFR 2 cross Metz and McLawhorn direct and settlement exhibit number 1.
Thank you, Chair Mitchell. Mr. McLawhorn, is the exhibits for DEP that begin on page 62 and go to page 85, do these pages appear to you to contain some of the information that Commissioner Clodfelter was asking you about?
Yes, they do, although I understood Commissioner Clodfelter, he wanted to see dollar values, and these are mostly peaks. Energy and that sort of thing. I think I understood him to say he wanted dollars, and I don't believe that's included in here.
Is there on DEP exhibit 18, which is page 81 of this exhibit?
There are revenue amounts in here.
Thank you. And then I'm sorry, DEP exhibit 18, which is
Those are revenues, so those are dollar values, but I had interpreted your question about plant dollar values, but if I misinterpreted, I apologize. But we can talk about this.
Thank you. Yeah, nope, we're good. Thank you. I just wanted to draw your attention to page 81 there. And then just Chair Mitchell, we would ask that the commission take judicial notice of its order adopting Commission Rule R-117B issued in docket number E-100 sub 178 on February 10th, 2022.
All right, the commission will take judicial notice of the order as requested by council.
Thank you. And then we also request that the commission take judicial notice of its order approving template notice and providing initial guidance on issues related to CPCN process and cost recovery under PBR and docket number E-100 sub 178 on September 8th, 2022.
The commission will take judicial notice of the order as requested by council.
Thank you. No further questions.
David Neal for NCJC et al. Mr. McLaughlin, you recall when Commissioner Clodfelter asked you a question about the relative benefits or risks of multi-year rate plan application?
Yes.
And as I recall, you started your response with a sort of a general disagreement with witness Bateman's characterization of those risks and benefits.
Her overall characterization, I disagree with, that there's really no benefit. There's no risk advantage to the company from having the multi-year rate plan. I don't want to misstate what she said, but I think she said she's very happy to have it, but she didn't think, you know, from a risk standpoint, the company was better off or something to that effect.
And then, as I recall, you enumerated a number of potential risks to ratepayers from the multi-year rate plan. Isn't that right?
Yes.
And then when it came to your assessment of benefits, you said it depends on what the commission does. Isn't that right?
I think it largely depends on the commission.
And you also, I think in that response, again, reiterated this concern with what you called the shadow MYRP.
Yes.
And by that, you meant the sort of capital expenditures that Duke plans that are outside of the MYRP.
Yes, there's significant expenditures that'll be taking place over the next 3 years that aren't part of the MYRP.
And Mr. Metz, if I can turn you back to your testimony at the bottom of page 76 on this same topic. You were asked about the total monetary impact of the company's proposed MYRP and non-MYRP capital spend over the next 3 years. And could you read your response for the sentence that starts on line 12 and then continues over to the next page ending line 2?
So page 76, line 12.
Yes, sir.
I have also noted that the company intends to book non-MYRP costs to be recovered in its next case that may equal or exceed the cost included in the MYRP. It is shocking that maintaining or improving the overall reliability of the company's entire electric system requires nearly a $9 billion capital project spend by the end of rate year 3.
And then if you could continue down to the sentence beginning on line 18 on that same page, 77.
Page 77, line 18. Given my estimate of the revenue impact of the company's MYRP and non-MYRP spend over the next 3 years, current rates will approximately double between now and the end of the company's next rate case.
Now, again, Mr. McLaughlin, you testified about, you know, concerns that a customer on the fixed income might face from rate increases like the ones that Mr. Metz just described. Isn't that right?
Well, customers on fixed incomes, customers not on fixed incomes, businesses, industry, everybody, yes.
So, I mean, as I read, Mr. Metz, as I read that part of your testimony on page 77, that was like a flashing red light to me. Isn't it? I would think that would be a particular concern for public staff. Isn't that right?
Yes, yes.
And, you know, you were asked by, I think, by at least one commissioner about guardrails. Wouldn't you agree that one guardrail is that the commission has the authority to deny the multi-year rate plan application?
They have the authority, but the public staff did not recommend that.
Thank you. I have no further questions.
All right, Duke.
Thank you. Very briefly, just to circle back to the questions that were in which you all were discussing scenarios in which projects, MYRP projects are changed, substituted. Do you recall those questions?
Yes.
And there's a variety of reasons for which, or circumstances under which future MYRP projects, the projected ones, may be changed, modified, substituted. You agree with that, correct?
Yes.
Could be because the project's no longer needed. Could be because the project need can be addressed in a more cost-effective manner. Is that a possible scenario?
Yes.
Also possible that there might be higher priority projects that emerge that provide greater benefit to customers, correct?
Yes, and I think I testified to that.
Yeah. And would you agree that it is in fact the company's affirmative responsibility as it implements the MYRP to make those decisions in real time as it goes about the execution of the MYRP?
Yes. Mr. Metz.
Yes. And in fact, the company will be held responsible for having made prudent and reasonable execution decisions as it implements the MYRP.
That's the way the law reads. It's, as we all know, it's very difficult once a project goes into service, but yes, the provision is there.
Okay. And there was extensive discussion regarding the ways in which the commission will be able to stay apprised of and aware of the extent to which the company executes or makes reasonable, prudent decisions to deviate from the MYRP projects. Do you recall those discussions?
There were discussions about how to monitor what happens, yes.
And are you, Mr. Metz or Ms. McLaughlin, do you recall the requirements imposed by this commission under R1-17B, subsection D2J as it relates to the quarterly reports that are required of the company?
I don't have that in front of me. I don't know if Mr. Metz does, if someone could provide a copy of that.
Yeah, I'll just briefly, subject to check, would it surprise you, or does this seems consistent with your memory that under that rule, the company is going to be required to report on a quarterly basis a list of all changes made to the MYRP projects?
I'll accept that subject to check.
Subject to check, the company is also required to provide the original and revised cost estimates for any changes, and the statement explaining the purpose and reason for every change for every MYRP project. Does that sound familiar?
Subject to check.
Assuming that's the obligations that have already been imposed on the company by the commission, do you think that will be a reasonable starting ground for ensuring that the company's changes are reasonable and prudent?
We would certainly want that information. I can't say what additional information, but that is certainly something that we would want.
And just to add on that, but I think that's what we're iterating, that's the starting point. But as we sit here and look at the potential ebb and flow of things, there might be further mechanics or enhancement that we would request.
Okay, thank you. Turning very briefly to PIMS, there was discussion around the fact that PIMS is a tool made available that does and can be used to provide benefit to customers. And that, would you agree that properly structured PIMS, are a part of this puzzle that can provide benefit to customers?
Properly structured and tracked PIMS, yes.
And you referenced a number of PIM settlements, and the public staff was in fact a part of the 2 PIM settlements filed in this case, correct?
Can you reference the
sure.
there multiple PIMs?
There was the original agreement and stipulation of settlement on performance incentive mechanisms filed on May 1st that public staff was a party to.
Right.
And there was a subsequent agreement and stipulation of partial settlement involving the withdrawal of the low income PIM, and public staff was part of that settlement as well.
Yes.
And to add on to that, but there was other items followed underneath the PIM, other settlements that we do not believe are appropriate and probably addressed by our witnesses at a later time, notably Mr. Williamson and Mr. Thomas.
Which PIM settlement is that, Mr.
I believe it's the one under the power quality.
Okay, I don't believe there's a PIM involved in that, but I understand that you were not a party to the power quality. So it's correct, though, is it not, that public staff believes and supports the modified PIMs that were identified and set forth in the 2 settlements that to which the public staff was a party?
we do support those PIMs that are in the settlements, but I guess the point I was trying to make was the proof will sort of be in the pudding, you know, what are how they perform and are they accurately tracked? But yes, as designed, we support those.
And as it relates to PIMS in this case, those settlements resolve PIMS issues as between the company and public staff.
Yes, we don't have any additional PIMs or PIMs modifications to propose at this time.
And so to that extent, you view the PIMs that are now supported by the settlements as a reasonable first attempt as we learn and as this commission learns how to fully leverage the value of PIMs in this process.
Yes, but I will caution, and as we alluded to in response to some other questions, by the time we get to the DEC case, we may have a different view on other PIMs, and we're not saying this is it forever. So
understood. And just two more lines of questions, and it'll be as brief as possible. Again, from the public staff's perspective, the partial revenue requirements settlement resolves the various concerns that you all had with respect to the MYRP capital and represents a reasonable compromise that should be approved by this commission.
I think there might be one qualifier, and I don't want to misspeak to what the actual settlement's saying. Can you point me to at least where the settlement we're saying resolves the public staff's concerns? That's the point I'm getting
Okay,
up on.
maybe I'll reframe. The public staff stands behind the settlement.
Yes.
Correct? And the settlement establishes a revenue requirement result with respect to the MYRP projects that public staff finds to be a reasonable outcome in this proceeding.
Yes. Okay.
Very last question here, Ms. McClawhorn, are you familiar? Did you get a chance to review Ms. Kendall Bowman's testimony, her rebuttal testimony?
I did. It's been a while since I read it, but I did.
So I'm going to just, we don't need to have a copy for him. I'm going to read from her testimony on page 19, line 8. She says, the company appreciates the detailed evaluation performed by public staff. Do you recall her testimony in that respect?
I believe I recall that statement. I recall some other statements too.
So you would agree then that the company didn't, Ms. Bowman did in fact recognize the detailed effort of the public staff in this proceeding?
She did.
Okay. No further questions. Thank you.
Just a few. And I think you just covered this with Mr. Jirak, but just to be clear, the public staff does support the partial stipulation of the revenue requirement between DEP and the public staff, correct?
Yes.
Yeah. And isn't it true that while the public staff supports the stipulation, the settlement does not cover every concern the public staff has about the company's ability to operate its system over the next 3 years?
Correct.
And in response to Commissioner McKissick's request for a late filed exhibit on potential guardrails for the company's reporting requirements in between rate cases, you stated that we could provide such a list.
I said we would try.
And while the public staff can anticipate issues that may occur in reviewing the company's implementation of the MYRP projects, or the implementation of the MYRP, and other capital projects outside the MYRP, you would agree that as the public staff conducts this first of a kind review of the implementation of the MYRP, the public staff would likely come up with many other guardrails that it could have never anticipated prior to conducting the review.
Yes, I think I tried to make that point on a couple of other occasions, including just recently with Mr. Jirak, as we approach the DEC case.
And there, to that end, with the guardrails and the reporting requirements that the company has to file, the company also had to, in its application for the MYRP, file detailed work papers for projects that were included in its MYRP, correct?
Mr. Most.
Yes.
Yes. And do you recall any discussions with the company over the level of detail required for those work papers?
And we're still referencing the Duke Energy Progress case and
Yes.
the initial filing. Yes, I recall many conversations.
So would you agree that it's probably a good idea for the public staff and the company to come to an agreement on the level of detail required and the reporting requirements that are in R117B prior to the company filing its first report?
Yes.
Yes.
I look forward to working with the company on that.
No further questions.
All right, we've come to the end of the day. Gentlemen, appreciate your testimony and your participation in this case. You all may step down and be excused. I will take motions from the parties.
Sigford 2 would move that it's cross-examination, Metz and McLaughlin, direct and settlement Exhibit 1 be entered into the record.
All right, your motion is allowed.
Public staff would move Mr. Metz's 2 exhibits and direct testimony into the record.
All right, that motion is allowed. All right, with that, we will be back.
Madam Chair.
Oh,
Make a motion if you don't mind on.
actually, Mr. Burns.
Yes.
You may be, please proceed with your motion. I'm
Okay.
sorry for.
No problem. Thank you very much. It's John Burns for CCBA, but I'm standing at the request of Mr. Snowden, the North Carolina League of Municipalities. He asked that I move on his behalf the excused testimony of Terry Mann, 9 pages filed on March 27th, 2023, into evidence. And the excused testimony of Bill Sappho, 16 pages filed on March 27th, into evidence.
All right, thank you, Mr. Burns. Your motion will be allowed that those testimonies will be copied into the record as if given orally from the stand at the appropriate time.
Thank you, ma'am.
All right, before we end for the day, as the public staff's request to excuse certain witnesses, that request is granted as to Evan Lawrence, Tommy Williamson, and Blaze Mishna. All right, with that, we are done for the day. We will be back on at 9:30 in the morning. We are in recess.